Hello guys, you are listening Laxmikanth Indian Polity, Part 1, Historical Background. He British came to India in 1600 as traders, in the form of East India Company, which had the exclusive right of trading in India under a charter granted by Queen Elizabeth I. In 1765, the company, which till now had purely trading functions, obtained the Diwani, that is, rights over revenue and civil justice, of Bengal, Bihar and Orissa. This started its career as territorial power. In 1858, in the wake of the Sepoy Mutiny, the British Crown assumed direct responsibility for the governance of India. This rule continued until India was granted independence on August 15, 1947. With independence came the need for a constitution. Hence, a constituent assembly was formed for this purpose in 1946, and on January 26, 1950, the Constitution came into being. However, various features of the Indian Constitution and polity have their roots in the British rule. There were certain events in the British rule that laid down the legal framework for the organization and functioning of government and administration in British India. These events have greatly influenced our constitution and polity. They are explained here in a chronological order under two major headings. 1. The Company Rule, 1773 to 1858. 2. The Crown Rule, 1858 to 1947. The Company Rule, 1773 to 1858. Regulating Act of 1773. This act was of great constitutional importance as, a. It was the first step taken by the British government to control and regulate the affairs of the East India Company in India. B. It recognized, for the first time, the political and administrative functions of the company. And, c. It laid the foundations of central administration in India. The features of this act were as follows. 1. It designated the Governor of Bengal as the Governor-General of Bengal and created an executive council of 4 members to assist him. The first such Governor-General was Lord Warren Hastings. 2. It made the governors of Bombay and Madras presidencies subordinate to the Governor-General of Bengal, unlike earlier, when the 3 presidencies were independent of one another. 3. It provided for the establishment of a Supreme Court at Calcutta, 1774, comprising 1 Chief Justice and 3 other judges. 4. It prohibited the servants of the company from engaging in any private trade or accepting presents or bribes from the natives. 5. It strengthened the control of the British government over the company by requiring the Court of Directors, governing body of the company, to report on its revenue, civil, and military affairs in India. Amending Act of 1781. In a bid to rectify the defects of the Regulating Act of 1773, the British Parliament passed the Amending Act of 1781, also known as the Act of Settlement. The features of this act were as follows. 1. It exempted the Governor-General and the Council from the jurisdiction of the Supreme Court for the acts done by them in their official capacity. Similarly, it also exempted the servants of the company from the jurisdiction of the Supreme Court for their official actions. 2. It excluded the revenue matters and the matters arising in the collection of revenue from the jurisdiction of the Supreme Court. 3. It provided that the Supreme Court was to have jurisdiction over all the inhabitants of Kolkata. It also required the court to administer the personal law of the defendants, that is, Hindus were to be tried according to the Hindu law and Muslims were to be tried according to the Mohammedan law. 4. It laid down that the appeals from the provincial courts could be taken to the Governor-General in Council and not to the Supreme Court. 5. It empowered the Governor-General in Council to frame regulations for the provincial courts and councils. Pitt's India Act of 1784. The next important act was the Pitt's India Act of 1784. The features of this act were as follows. 1. It distinguished between the commercial and political functions of the company. 2. It allowed the Court of Directors to manage the commercial affairs, but created a new body called Board of Control to manage the political affairs. Thus, it established a system of double government. 3. It empowered the Board of Control to supervise and direct all operations of the civil and military government or revenues of the British possessions in India. Thus, the Act was significant for two reasons. First, the company's territories in India were for the first time called the British possessions in India, and second, the British government was given the supreme control over company's affairs and its administration in India. Act of 1786. In 1786, Lord Cornwallis was appointed as the Governor-General of Bengal. He placed two demands to accept that post, viz. 1. He should be given power to override the decision of his council in special cases. 2. He would also be the Commander-in-Chief. Accordingly, the Act of 1786 was enacted to make both the provisions. Charter Act of 1793. The features of this act were as follows. 1. It extended the overriding power given to Lord Cornwallis over his council, to all future Governor-Generals and Governors of Presidencies. 2. It gave the Governor-General more powers and control over the governments of the subordinate presidencies of Bombay and Madras. 3. It extended the trade monopoly of the company in India for another period of 20 years. 4. It provided that the Commander-in-Chief was not to be a member of the Governor-General's Council, unless he was so appointed. 5. It laid down that the members of the Board of Control and their staff were, henceforth, to be paid out of the Indian revenues. Charter Act of 1813. The features of this act were as follows. 1. It abolished the trade monopoly of the company in India, that is, the Indian trade was thrown open to all British merchants. However, it continued the monopoly of the company over trade in tea and trade with China. 2. It asserted the sovereignty of the British Crown over the company's territories in India. 3. It allowed the Christian missionaries to come to India for the purpose of enlightening the people. 4. It provided for the spread of Western education among the inhabitants of the British territories in India. 5. It authorized the local governments in India to impose taxes on persons. They could also punish the persons for not paying taxes. Charter Act of 1833. This act was the final step towards centralization in British India. The features of this act were as follows. 1. It made the Governor-General of Bengal as the Governor-General of India and vested in him all civil and military powers. Thus, the act created, for the first time, Government of India having authority over the entire territorial area possessed by the British in India. Lord William Bentinck was the first Governor-General of India. 2. It deprived the Governor of Bombay and Madras of their legislative powers. The Governor-General of India was given exclusive legislative powers for the entire British India. The laws made under the previous acts were called as regulations, while laws made under this act were called as acts. 3. It ended the activities of the East India Company as a commercial body, which became a purely administrative body. It provided that the company's territories in India were held by it in trust for His Majesty, his heirs and successors. 4. The Charter Act of 1833 attempted to introduce a system of open competition for selection of civil servants and stated that the Indian should not be debarred from holding any place, office and employment under the company. However, this provision was negated after opposition from the Court of Directors. Charter Act of 1853. This was the last of the series of Charter Acts passed by the British Parliament between 1793 and 1853. It was a significant constitutional landmark. The features of this act were as follows. 1. It separated, for the first time, the legislative and executive functions of the Governor-General's Council. It provided for addition of 6 new members called legislative councillors to the council. In other words, it established a separate Governor-General's Legislative Council which came to be known as the Indian Central Legislative Council. This legislative wing of the council functioned as a mini-parliament, adopting the same procedures as the British Parliament. Thus, legislation, for the first time, was treated as a special function of the government, requiring special machinery and special process. 2. It introduced an open competition system of selection and recruitment of civil servants. The covenanted civil service was, thus, thrown open to the Indians also. Accordingly, the Macaulay Committee, the Committee on the Indian Civil Service, was appointed in 1854. 3. It extended the company's rule and allowed it to retain the possession of Indian territories on trust for the British Crown. But, it did not specify any particular period, unlike the previous charters. This was a clear indication that the company's rule could be terminated at any time the Parliament liked. 4. It introduced, for the first time, local representation in the Indian Central Legislative Council. Of the 6 new legislative members of the Governor-General's Council, 4 members were appointed by the local, provincial governments of Madras, Bombay, Bengal, and Agra. The Crown Rule, 1858 to 1947. Government of India Act of 1858. This significant act was enacted in the wake of the Revolt of 1857. Also known as the First War of Independence or the Sepoy Mutiny. The act, known as the Act for the Good Government of India, abolished the East India Company, and transferred the powers of government, territories and revenues to the British Crown. The features of this act were as follows. 1. It provided that India, henceforth, was to be governed by, and in the name of, Her Majesty. It changed the designation of the Governor-General of India to that of Viceroy of India. He, Viceroy, was the direct representative of the British Crown in India. Lord Canning, thus, became the first Viceroy of India. 2. It ended the system of double government by abolishing the Board of Control and Court of Directors. 3. It created a new office, Secretary of State for India, vested with complete authority and control over Indian administration. The Secretary of State was a member of the British Cabinet and was responsible ultimately to the British Parliament. 4. It established a 15-member Council of India to assist the Secretary of State for India. The Council was an advisory body. The Secretary of State was made the chairman of the Council. 5. It constituted the Secretary of State and Council as a body corporate, capable of suing and being sued in India and in England. The Act of 1858 was, however, largely confined to the improvement of the administrative machinery by which the Indian government was to be supervised and controlled in England. It did not alter in any substantial way the system of government that prevailed in India. Indian Councils Act of 1861. After the Great Revolt of 1857, the British government felt the necessity of seeking the cooperation of the Indians in the administration of their country. In pursuance of this policy of association, 3 acts were enacted by the British Parliament in 1861, 1892 and 1909. The Indian Councils Act of 1861 is an important landmark in the constitutional and political history of India. The features of this act were as follows. 1. It made a beginning of the representative institutions by associating Indians with the lawmaking process. It, thus, provided that the Viceroy should nominate some Indians as non-official members of his expanded council. In 1862, Lord Canning, the then Viceroy, nominated 3 Indians to his legislative council: the Raja of Benares, the Maharaja of Patiala, and Sir Dinker Rao. 2. It initiated the process of decentralization by restoring the legislative powers to the Bombay and Madras presidencies. It, thus, reversed the centralizing tendency that started from the Regulating Act of 1773 and reached its climax under the Charter Act of 1833. This policy of legislative devolution resulted in the grant of almost complete internal autonomy to the provinces in 1937. 3. It also provided for the establishment of new legislative councils for Bengal, northwestern provinces and Punjab, which were established in 1862, 1886 and 1897, respectively. 4. It empowered the Viceroy to make rules and orders for the more convenient transaction of business in the council. It also gave a recognition to the portfolio system, introduced by Lord Canning in 1859. Under this, a member of the Viceroy's council was made in charge of one or more departments of the government and was authorized to issue final orders on behalf of the council on matters of his departments. 5. It empowered the Viceroy to issue ordinances, without the concurrence of the Legislative Council, during an emergency. The life of such an ordinance was 6 months. Indian Councils Act of 1892. The features of this act were as follows. 1. It increased the number of additional, non-official, members in the central and provincial legislative councils, but maintained the official majority in them. 2. It increased the functions of legislative councils and gave them the power of discussing the budget. 5. And addressing questions to the executive. 3. It provided for the nomination of some non-official members of the Central Legislative Council by the Viceroy on the recommendation of the provincial legislative councils and the Bengal Chamber of Commerce, and that of the provincial legislative councils by the governors on the recommendation of the district boards, municipalities, universities, trade associations, zamindars and chambers. The Act made a limited and indirect provision for the use of election in filling up some of the non-official seats both in the central and provincial legislative councils. The word election was, however, not used in the Act. The process was described as nomination made on the recommendation of certain bodies. Indian Councils Act of 1909. This Act is also known as Morley-Minto Reforms. Lord Morley was the then Secretary of State for India and Lord Minto was the then Viceroy of India. The features of this act were as follows. 1. It considerably increased the size of the legislative councils, both central and provincial. The number of members in the Central Legislative Council was raised from 16 to 60. The number of members in the provincial legislative councils was not uniform. 2. It retained official majority in the Central Legislative Council, but allowed the provincial legislative councils to have non-official majority. 3. It enlarged the deliberative functions of the legislative councils at both the levels. For example, members were allowed to ask supplementary questions, move resolutions on the budget and so on. 4. It provided, for the first time, for the association of Indians with the executive councils of the Viceroy and governors. Satyendra Prasad Sinha became the first Indian to join the Viceroy's executive council. He was appointed as the law member. 5. It introduced a system of communal representation for Muslims by accepting the concept of separate electorate. Under this, the Muslim members were to be elected only by Muslim voters. Thus, the Act legalized communalism and Lord Minto came to be known as the father of communal electorate. 6. It also provided for the separate representation of presidency corporations, chambers of commerce, universities and zamindars. Government of India Act of 1919. On August 20, 1917, the British government declared, for the first time, that its objective was the gradual introduction of responsible government in India. The Government of India Act of 1919 was thus enacted, which came into force in 1921. This act is also known as Montagu-Chelmsford Reforms. Montagu was the Secretary of State for India and Lord Chelmsford was the Viceroy of India. The features of this act were as follows. 1. It relaxed the central control over the provinces by demarcating and separating the central and provincial subjects. The central and provincial legislatures were authorized to make laws on their respective list of subjects. However, the structure of government continued to be centralized and unitary. 2. It further divided the provincial subjects into two parts: transferred and reserved. The transferred subjects were to be administered by the governor with the aid of ministers responsible to the Legislative Council. The reserved subjects, on the other hand, were to be administered by the governor and his Executive Council without being responsible to the Legislative Council. This dual scheme of governance was known as diarchy, a term derived from the Greek word diarch, which means double rule. However, this experiment was largely unsuccessful. 3. It introduced, for the first time, bicameralism and direct elections in the country. Thus, the Indian Legislative Council was replaced by a bicameral legislature consisting of an upper house, Council of State, and a lower house, Legislative Assembly. The majority of members of both the houses were chosen by direct election. 4. It required that the 3 of the 6 members of the Viceroy's Executive Council, other than the Commander-in-Chief, were to be Indian. 5. It extended the principle of communal representation by providing separate electorates for Sikhs, Indian Christians, Anglo-Indians and Europeans. 6. It granted franchise to a limited number of people on the basis of property, tax or education. 7. It created a new office of the High Commissioner for India in London and transferred to him some of the functions hitherto performed by the Secretary of State for India. 8. It provided for the establishment of a Public Service Commission. Hence, a Central Public Service Commission was set up in 1926 for recruiting civil servants. 9. It separated, for the first time, provincial budgets from the central budget and authorized the provincial legislatures to enact their budgets. 10. It provided for the appointment of a statutory commission to inquire into and report on its working after 10 years of its coming into force, Simon Commission. In November 1927 itself, that is, 2 years before the schedule, the British government announced the appointment of a 7-member statutory commission under the chairmanship of Sir John Simon to report on the condition of India under its new constitution. All the members of the commission were British and hence, all the parties boycotted the commission. The commission submitted its report in 1930 and recommended the abolition of diarchy, extension of responsible government in the provinces, establishment of a federation of British India and princely states, continuation of communal electorate and so on. To consider the proposals of the Commission, the British government convened 3 round-table conferences of the representatives of the British government, British India and Indian princely states. On the basis of these discussions, a white paper on constitutional reforms was prepared and submitted for the consideration of the Joint Select Committee of the British Parliament. The recommendations of this committee were incorporated, with certain changes, in the next Government of India Act of 1935. Communal Award. In August 1932, Ramsay MacDonald, the British Prime Minister, announced a scheme of representation of the minorities, which came to be known as the Communal Award. The award not only continued separate electorates for the Muslims, Sikhs, Indian Christians, Anglo-Indians and Europeans but also extended it to the depressed classes, scheduled castes. Gandhiji was distressed over this extension of the principle of communal representation to the depressed classes and undertook fast unto death in Yerawada jail, Pune, to get the award modified. At last, there was an agreement between the leaders of the Congress and the depressed classes. The agreement, known as Pune Pact, retained the Hindu joint electorate and gave reserved seats to the depressed classes. Government of India Act of 1935. The Act marked a second milestone towards a completely responsible government in India. It was a lengthy and detailed document having 321 sections and 10 schedules. The features of this act were as follows. 1. It provided for the establishment of an All India Federation consisting of provinces and princely states as units. The Act divided the powers between the centre and units in terms of 3 lists: Federal List, for centre, with 59 items, Provincial List, for provinces, with 54 items, and the Concurrent List, for both, with 36 items. Residuary powers were given to the Viceroy. However, the Federation never came into being as the princely states did not join it. 2. It abolished diarchy in the provinces and introduced provincial autonomy in its place. The provinces were allowed to act as autonomous units of administration in their defined spheres. Moreover, the Act introduced responsible governments in provinces, that is, the governor was required to act with the advice of ministers responsible to the provincial legislature. This came into effect in 1937 and was discontinued in 1939. 3. It provided for the adoption of diarchy at the center. Consequently, the federal subjects were divided into reserved subjects and transferred subjects. However, this provision of the Act did not come into operation at all. 4. It introduced bicameralism in 6 out of 11 provinces. Thus, the legislatures of Bengal, Bombay, Madras, Bihar, Assam and the United Provinces were made bicameral, consisting of a legislative council, upper house, and a legislative assembly, lower house. However, many restrictions were placed on them. 5. It further extended the principle of communal representation by providing separate electorates for depressed classes, scheduled castes, women and labor, workers. 6. It abolished the Council of India, established by the Government of India Act of 1858. The Secretary of State for India was provided with a team of advisors. 7. It extended franchise. About 10% of the total population got the voting right. 8. It provided for the establishment of a Reserve Bank of India to control the currency and credit of the country. 9. It provided for the establishment of not only a Federal Public Service Commission, but also a Provincial Public Service Commission and Joint Public Service Commission for 2 or more provinces. 10. It provided for the establishment of a federal court, which was set up in 1937. Indian Independence Act of 1947. On February 20, 1947, the British Prime Minister Clement Attlee declared that the British rule in India would end by June 30, 1948, after which the power would be transferred to responsible Indian hands. This announcement was followed by the agitation by the Muslim League demanding partition of the country. Again on June 3, 1947, the British government made it clear that any constitution framed by the Constituent Assembly of India, formed in 1946, cannot apply to those parts of the country which were unwilling to accept it. On the same day, June 3, 1947, Lord Mountbatten, the Viceroy of India, put forth a partition plan, known as the Mountbatten Plan. The plan was accepted by the Congress and the Muslim League. Immediate effect was given to the plan by enacting the Indian Independence Act, 1947. The features of this act were as follows. 1. It ended the British rule in India and declared India as an independent and sovereign state from August 15, 1947. 2. It provided for the partition of India and creation of two independent dominions of India and Pakistan with the right to secede from the British Commonwealth. 3. It abolished the office of Viceroy and provided, for each dominion, a Governor-General, who was to be appointed by the British King on the advice of the Dominion Cabinet. His Majesty's government in Britain was to have no responsibility with respect to the government of India or Pakistan. 4. It empowered the constituent assemblies of the two dominions to frame and adopt any constitution for their respective nations and to repeal any act of the British Parliament, including the Independence Act itself. 5. It empowered the constituent assemblies of both the dominions to legislate for their respective territories till the new constitutions were drafted and enforced. No act of the British Parliament passed after August 15, 1947 was to extend to either of the new dominions unless it was extended thereto by a law of the legislature of the dominion. 6. It abolished the office of the Secretary of State for India and transferred his functions to the Secretary of State for Commonwealth Affairs. 7. It proclaimed the lapse of British paramountcy over the Indian princely states and treaty relations with tribal areas from August 15, 1947. 8. It granted freedom to the Indian princely states either to join the Dominion of India or Dominion of Pakistan or to remain independent. 9. It provided for the governance of each of the dominions and the provinces by the Government of India Act of 1935, till the new constitutions were framed. The dominions were however authorized to make modifications in the Act. 10. It deprived the British monarch of his right to veto bills or ask for a reservation of certain bills for his approval. But, this right was reserved for the Governor-General. The Governor-General would have full power to assent to any bill in the name of His Majesty. 11. It designated the Governor-General of India and the provincial governors as constitutional, nominal, heads of the states. They were made to act on the advice of the respective Council of Ministers in all matters. 12. It dropped the title of Emperor of India from the royal titles of the King of England. 13. It discontinued the appointment to civil services and reservation of posts by the Secretary of State for India. The members of the civil services appointed before August 15, 1947 would continue to enjoy all benefits that they were entitled to till that time. At the stroke of midnight of 14th-15th of August, 1947, the British rule came to an end and power was transferred to the two new independent dominions of India and Pakistan. Lord Mountbatten became the first Governor-General of the new Dominion of India. He swore in Jawaharlal Nehru as the first Prime Minister of independent India. The Constituent Assembly of India formed in 1946 became the Parliament of the Indian Dominion. If this audiobook helped you in any way, so please do like and share this audiobook, and please hit the subscribe button. Laxmikanth Indian Polity Part 1, Chapter 2. Making of the Constitution. Demand for a Constituent Assembly. It was in 1934 that the idea of a Constituent Assembly for India was put forward for the first time by M.N. Roy, a pioneer of communist movement in India. In 1935, the Indian National Congress, Incorporated, for the first time, officially demanded a Constituent Assembly to frame the Constitution of India. In 1938, Jawaharlal Nehru, on behalf of the Incorporated, declared that the Constitution of Free India must be framed, without outside interference, by a constituent assembly elected on the basis of adult franchise. The demand was finally accepted in principle by the British government in what is known as the August Offer of 1940. In 1942, Sir Stafford Cripps, a member of the cabinet, came to India with a draft proposal of the British government on the framing of an independent constitution to be adopted after the World War II. The Cripps proposals were rejected by the Muslim League, which wanted India to be divided into two autonomous states with two separate constituent assemblies. Finally, a cabinet mission was sent to India. While it rejected the idea of two constituent assemblies, it put forth a scheme for the Constituent Assembly which more or less satisfied the Muslim League. Composition of the Constituent Assembly. The Constituent Assembly was constituted in November 1946 under the scheme formulated by the Cabinet Mission Plan. The features of the scheme were: 1. The total strength of the Constituent Assembly was to be 389. Of these, 296 seats were to be allotted to British India and 93 seats to the princely states. Out of 296 seats allotted to the British India, 292 members were to be drawn from the 11 governors' provinces and 4 from the 4 chief commissioners' provinces, 1 from each. 2. Each province and princely state, or group of states in case of small states, were to be allotted seats in proportion to their respective population. Roughly, 1 seat was to be allotted for every million population. 3. Seats allocated to each British province were to be divided among the 3 principal communities: Muslims, Sikhs in general, all except Muslims and Sikhs, in proportion to their population. 4. The representatives of each community were to be elected by members of that community in the provincial legislative assembly, and voting was to be by the method of proportional representation by means of single transferable vote. 5. The representatives of the princely states were to be nominated by the heads of the princely states. It is, thus, clear that the Constituent Assembly was to be a partly elected and partly nominated body. Moreover, the members were to be indirectly elected by the members of the provincial assemblies, who themselves were elected on a limited franchise. The elections to the Constituent Assembly, for 296 seats allotted to the British Indian provinces, were held in July to August 1946. The Indian National Congress won 208 seats, the Muslim League 73 seats, and the small groups and independents got the remaining 15 seats. However, the 93 seats allotted to the princely states were not filled as they decided to stay away from the Constituent Assembly. Although the Constituent Assembly was not directly elected by the people of India on the basis of adult franchise, the Assembly comprised representatives of all sections of the Indian society: Hindus, Muslims, Sikhs, Parsis, Anglo-Indians, Indian Christians, SCs, STs, including women of all these sections. The Assembly included all important personalities of India at that time, with the exception of Mahatma Gandhi. Working of the Constituent Assembly. The Constituent Assembly held its first meeting on December 9, 1946. The Muslim League boycotted the meeting and insisted on a separate state of Pakistan. The meeting was, thus, attended by only 211 members. Dr. Sachidananda Sinha, the oldest member, was elected as the temporary president of the Assembly, following the French practice. Later, Dr. Rajendra Prasad was elected as the president of the Assembly. Similarly, both H.C. Mukherjee and V.T. Krishnamachari were elected as the vice presidents of the Assembly. In other words, the Assembly had 2 vice presidents. Objectives Resolution on December 13, 1946, Jawaharlal Nehru moved the historic Objectives Resolution in the Assembly. It laid down the fundamentals and philosophy of the constitutional structure. It read: 1. This Constituent Assembly declares its firm and solemn resolve to proclaim India as an independent sovereign republic and to draw up for her future governance a constitution. 2. Wherein the territories that now comprise British India, the territories that now form the Indian states and such other parts of India as are outside India and the states as well as other territories as are willing to be constituted into the independent sovereign India, shall be a union of them all. And 3. Wherein the said territories, whether with their present boundaries or with such others as may be determined by the Constituent Assembly and thereafter according to the law of the Constitution, shall possess and retain the status of autonomous units together with residuary powers and exercise all powers and functions of government and administration save and except such powers and functions as are vested in or assigned to the Union or as are inherent or implied in the Union or resulting therefrom. And 4. Wherein all power and authority of the sovereign independent India, its constituent parts and organs of government are derived from the people. And 5. Wherein shall be guaranteed and secured to all the people of India justice, social, economic and political, equality of status of opportunity, and before the law, freedom of thought, expression, belief, faith, worship, vocation, association and action, subject to law and public morality. And 6. Wherein adequate safeguards shall be provided for minorities, backward and tribal areas, and depressed and other backward classes. And 7. Whereby shall be maintained the integrity of the territory of the Republic and its sovereign rights on land, sea and air according to justice and the law of civilized nations. And 8. This ancient land attains its rightful and honored place in the world and makes its full and willing contribution to the promotion of world peace and the welfare of mankind. This resolution was unanimously adopted by the Assembly on January 22, 1947. It influenced the eventual shaping of the Constitution through all its subsequent stages. Its modified version forms the preamble of the present Constitution. Changes by the Independence Act. The representatives of the princely states, who had stayed away from the Constituent Assembly, gradually joined it. On April 28, 1947, representatives of the 6 states were part of the Assembly. After the acceptance of the Mountbatten Plan of June 3, 1947, for the partition of the country, the representatives of most of the other princely states took their seats in the Assembly. The members of the Muslim League from the Indian Dominion also entered the Assembly. The Indian Independence Act of 1947 made the following 3 changes in the position of the Assembly. 1. The Assembly was made a fully sovereign body, which could frame any constitution it pleased. The Act empowered the Assembly to abrogate or alter any law made by the British Parliament in relation to India. 2. The Assembly also became a legislative body. In other words, 2 separate functions were assigned to the Assembly, that is, making of the Constitution for Free India and enacting of ordinary laws for the country. These 2 tasks were to be performed on separate days. Thus, the Assembly became the first Parliament of Free India, Dominion legislature. Whenever the Assembly met as the constituent body, it was chaired by Dr. Rajendra Prasad, and when it met as the legislative body, it was chaired by G.V. Mavlankar. These 2 functions continued till November 26, 1949, when the task of making the Constitution was over. 3. The Muslim League members, hailing from the areas included in the Pakistan, withdrew from the Constituent Assembly for India. Consequently, the total strength of the Assembly came down to 299 as against 389 originally fixed in 1946 under the Cabinet Mission Plan. The strength of the Indian provinces, formerly British provinces, was reduced from 296 to 229 and those of the princely states from 93 to 70. The state-wise membership of the Assembly is on December 31, 1947. Other functions performed: in addition to the making of the Constitution and enacting of ordinary laws, the Constituent Assembly also performed the following functions. 1. It ratified the India's membership of the Commonwealth in May 1949. 2. It adopted the national flag on July 22, 1947. 3. It adopted the national anthem on January 24, 1950. 4. It adopted the national song on January 24, 1950. 5. It elected Dr. Rajendra Prasad as the first President of India on January 24, 1950. In all, the Constituent Assembly had 11 sessions over 2 years, 11 months and 18 days. The constitution makers had gone through the constitutions of about 60 countries, and the draft constitution was considered for 114 days. The total expenditure incurred on making the Constitution amounted to 64 lakh rupees. On January 24, 1950, the Constituent Assembly held its final session. It, however, did not end, and continued as the Provisional Parliament of India from January 26, 1950, till the formation of new Parliament after the first general elections in 1951-52. Committees of the Constituent Assembly. The Constituent Assembly appointed a number of committees to deal with different tasks of constitution making. Out of these, 8 were major committees and the others were minor committees. The names of these committees and their chairmen are given below. Major committees. 1. Union Powers Committee, Jawaharlal Nehru. 2. Union Constitution Committee, Jawaharlal Nehru. 3. Provincial Constitution Committee, Sardar Patel. 4. Drafting Committee, Dr. B.R. Ambedkar. 5. Advisory Committee on Fundamental Rights, Minorities and Tribal and Excluded Areas, Sardar Patel. This committee had the following 5 subcommittees. A. Fundamental Rights Subcommittee, J.B. Kripalani. B. Minorities Subcommittee, H.C. Mukherjee. C. Northeast Frontier Tribal Areas and Assam Excluded and Partially Excluded Areas Subcommittee, Gopinath Bardaloy. D. Excluded and Partially Excluded Areas, other than those in Assam, Subcommittee, A.V. Thakur. E. Northwest Frontier Tribal Areas Subcommittee. 6. Rules of Procedure Committee, Dr. Rajendra Prasad. 7. States Committee, Committee for Negotiating with States, Jawaharlal Nehru. 8. Steering Committee, Dr. Rajendra Prasad. Minor Committees. 1. Finance and Staff Committee, Dr. Rajendra Prasad. 2. Credentials Committee, Alati Krishnaswamy Iyer. 3. House Committee, B. Patabi Sitaramaya. 4. Order of Business Committee, Dr. K. M. Munshi. 5. Ad Hoc Committee on the National Flag, Dr. Rajendra Prasad. 6. Committee on the Functions of the Constituent Assembly, G. V. Mavalankar. 7. Ad Hoc Committee on the Supreme Court, S. Varadchari, not an Assembly member. 8. Committee on Chief Commissioners Provinces, B. Patabi Sitaramaya. 9. Expert Committee on the Financial Provisions of the Union Constitution, Nalini Ranjan Sarkar, not an Assembly member. 10. Linguistic Provinces Commission, S. K. Dar, not an Assembly member. 11. Special Committee to Examine the Draft Constitution, Jawaharlal Nehru. 12. Press Gallery Committee, Usha Nath Sen. 13. Ad Hoc Committee on Citizenship, S. Varadchari, not an Assembly member. Drafting Committee. Among all the committees of the Constituent Assembly, The most important committee was the drafting committee set up on August 29, 1947. It was this committee that was entrusted with the task of preparing a draft of the new Constitution. It consisted of 7 members. They were 1. Dr. B.R. Ambedkar, Chairman. 2. N. Gopalaswamy Iyengar. 3. Aladi Krishnaswamy Iyer. 4. Dr. K. M. Munshi. 5. Syed Muhammad Sadullah. 6. And Madhava Rao. He replaced B. L. Mitter, who resigned due to ill health. 7. T. T. Krishnamachari. He replaced D. P. Khaitan, who died in 1948. The drafting committee, after taking into consideration the proposals of the various committees, prepared the first draft of the Constitution of India, which was published in February 1948. The people of India were given 8 months to discuss the draft and propose amendments. In the light of the public comments, criticisms and suggestions, the drafting committee prepared a second draft, which was published in October 1948. The drafting committee took less than 6 months to prepare its draft. In all, it sat only for 141 days. Enactment of the Constitution. Dr. B.R. Ambedkar introduced the final draft of the Constitution in the Assembly on November 4, 1948. First reading. The Assembly had a general discussion on it for 5 days, till November 9, 1948. The second reading, clause-by-clause consideration, started on November 15, 1948, and ended on October 17, 1949. During this stage, as many as 7,653 amendments were proposed and 2,473 were actually discussed in the Assembly. The third reading of the draft started on November 14, 1949. Dr. B.R. Ambedkar moved a motion the Constitution as settled by the Assembly be passed. The motion on draft Constitution was declared as passed on November 26, 1949, and received the signatures of the members and the President. Out of a total 299 members of the Assembly, only 284 were actually present on that day and signed the Constitution. This is also the date mentioned in the preamble as the date on which the people of India and the Constituent Assembly adopted, enacted and gave to themselves this Constitution. The Constitution, as adopted on November 26, 1949, contained a preamble, 395 articles and 8 schedules. The preamble was enacted after the entire Constitution was already enacted. Dr. B.R. Ambedkar, the then law minister, piloted the draft Constitution in the Assembly. He took a very prominent part in the deliberations of the Assembly. He was known for his logical, forceful and persuasive arguments on the floor of the Assembly. He is recognized as the father of the Constitution of India. This brilliant writer, constitutional expert, undisputed leader of the scheduled castes and the chief architect of the Constitution of India is also known as a modern Manu. Enforcement of the Constitution. Some provisions of the Constitution pertaining to citizenship, elections, provisional parliament, temporary and transitional provisions, and short title contained in Articles 5, 6, 7, 8, 9, 60, 324, 366, 367, 379, 380, 388, 391, 392 and 393 came into force on November 26, 1949, itself. The remaining provisions, the major part, of the Constitution came into force on January 26, 1950. This day is referred to in the Constitution as the date of its commencement, and celebrated as the Republic Day. January 26 was specifically chosen as the date of commencement of the Constitution because of its historical importance. It was on this day in 1930 that Purna Swaraj Day was celebrated, following the resolution of the Lahore Session, December 1929, of the incorporated with the commencement of the Constitution, the Indian Independence Act of 1947 and the Government of India Act of 1935, with all enactments amending or supplementing the latter act, were repealed. The Abolition of Privy Council Jurisdiction Act, 1949, was however continued. Experts Committee of the Congress. While elections to the Constituent Assembly were still in progress, on July 8, 1946, the Congress Party, Indian National Congress, appointed an experts committee for the purpose of preparing material for the Constituent Assembly. This committee consisted of the following members: 1. Jawaharlal Nehru, Chairman. 2. M. Asaf Ali. 3. K. M. Munshi. 4. N. Gopalaswamy Iyengar. 5. K. T. Shah. 6. D. R. Gadgil. 7. Humayun Kabir. 8. K. Santanam. Later, on the chairman's proposal, it was resolved that Krishna Kripalani be co-opted as member and convener of the committee. The committee had 2 sittings, the first at New Delhi from July 20 to 22, 1946, and the second at Bombay from August 15 to 17, 1946. Apart from a number of notes prepared by its members, the committee discussed the procedure to be adopted by the Constituent Assembly, the question of the appointment of various committees and the draft of a resolution on the objectives of the Constitution to be moved during the first session of the Constituent Assembly. On the role played by this committee in the making of the Constitution, Granville Austin, a British constitutional expert, observed, "It was the Congress Experts Committee that set India on the road to her present constitution." The committee members, working within the framework of the Cabinet Mission Scheme, made general suggestions about autonomous areas, the powers of provincial governments and the center, and about such issues as the princely states and the amending power. They also drafted a resolution, closely resembling the Objectives Resolution. Criticism of the Constituent Assembly. The critics have criticized the Constituent Assembly on various grounds. These are as follows. 1. Not a representative body. The critics have argued that the Constituent Assembly was not a representative body as its members were not directly elected by the people of India on the basis of universal adult franchise. 2. Not a sovereign body. The critics maintain that the Constituent Assembly was not a sovereign body as it was created by the proposals of the British government. Further, they said that the Assembly held its sessions with the permission of the British government. 3. Time-consuming. According to the critics, the Constituent Assembly took unduly long time to make the Constitution. They stated that the framers of the American Constitution took only 4 months to complete their work. In this context, Naziruddin Ahmed, a member of the Constituent Assembly, coined a new name for the drafting committee to show his contempt for it. He called it a drifting committee. 4. Dominated by Congress. The critics charged that the Constituent Assembly was dominated by the Congress Party. Granville Austin, an American constitutional expert, remarked, "The Constituent Assembly was a one-party body in an essentially one-party country. The Assembly was the Congress and the Congress was India." 5. Lawyer-politician domination. It is also maintained by the critics that the Constituent Assembly was dominated by lawyers and politicians. They pointed out that other sections of the society were not sufficiently represented. This, to them, is the main reason for the bulkiness and complicated language of the Constitution. 6. Dominated by Hindus. According to some critics, the Constituent Assembly was a Hindu-dominated body. Lord Viscount Simon called it a body of Hindus. Similarly, Winston Churchill commented that the Constituent Assembly represented only one major community in India. Important facts. 1. Elephant was adopted as the symbol, seal, of the Constituent Assembly. 2. Sir B. N. Rao was appointed as the constitutional advisor, legal advisor, to the Constituent Assembly. 3. H. V. R. Iyengar was the secretary to the Constituent Assembly. 4. S. N. Mukherjee was the chief draftsman of the Constitution in the Constituent Assembly. 5. Prem Behari Narain Raizada was the calligrapher of the Indian Constitution. The original Constitution was handwritten by him in a flowing italic style. 6. The original version was beautified and decorated by artists from Shantiniketan including Nand Lal Bose and Behar Ramanohar Sinha. 7. Behar Ramanohar Sinha illuminated, beautified and ornamented the original preamble calligraphed by Prem Behari Narain Raizada. 8. The calligraphy of the Hindi version of the original Constitution was done by Vasant Krishan Vaidya and elegantly decorated and illuminated by Nand Lal Bose. Hindi text of the Constitution. Originally, the Constitution of India did not make any provision with respect to an authoritative text of the Constitution in the Hindi language. Later, a provision in this regard was made by the 58th Constitutional Amendment Act of 1987. This amendment inserted a new Article 394A in the last part of the Constitution, Part 22. This article contains the following provisions. 1. The President shall cause to be published under his authority 1. The translation of the Constitution in Hindi language. The modifications which are necessary to bring it in conformity with the language, style and terminology adopted in the authoritative texts of the central acts in Hindi can be made in it. All the amendments of the Constitution made before such publication should be incorporated in it. 2. The translation in Hindi of every amendment of the Constitution made in English. 2. The translation of the Constitution and its every amendment published shall be construed to have the same meaning as the original text in English. If any difficulty arises in this matter, the President shall cause the Hindi text to be revised suitably. 3. The translation of the Constitution and its every amendment published shall be deemed to be, for all purposes, its authoritative text in Hindi. If this audiobook helped you in any way, so please do like and share this video and please hit the subscribe button. Laxmikanth Indian Polity. Part 1 Chapter 3. Salient Features of the Constitution. The Indian Constitution is unique in its contents and spirit. Though borrowed from almost every constitution of the world, the Constitution of India has several salient features that distinguish it from the constitutions of the other countries. It should be noted at the outset that a number of original features of the Constitution, as adopted in 1949, have undergone a substantial change, on account of several amendments, particularly 7th, 42nd, 44th, 73rd, 74th, 97th and 101st Amendments. In fact, the 42nd Amendment Act, 1976, is known as Mini-Constitution due to the important and large number of changes made by it in various parts of the Constitution. However, in the Kesva Anand Bharti case, 1973, the Supreme Court ruled that the constituent power of Parliament under Article 368 does not enable it to alter the basic structure of the Constitution. Salient features of the Constitution. The salient features of the Constitution, as it stands today, are as follows. 1. Lengthiest written Constitution. Constitutions are classified into written, like the American Constitution, or unwritten, like the British Constitution. The Constitution of India is the lengthiest of all the written constitutions of the world. It is a very comprehensive, elaborate and detailed document. Originally, 1949, the Constitution contained a preamble, 395 articles, divided into 22 parts, and 8 schedules. Presently, 2019, It consists of a preamble, about 470 articles, divided into 25 parts, and 12 schedules. The various amendments carried out since 1951 have deleted about 20 articles in one part, 7, and added about 95 articles, 4 parts, 4A, 9A, 9B and 14A, and 4 schedules, 9, 10, 11 and 12. No other constitution in the world has so many articles and schedules. 4 factors have contributed to the elephantine size of our constitution. They are: A. Geographical factors, that is, the vastness of the country and its diversity. B. Historical factors, for example, the influence of the Government of India Act of 1935, which was bulky. C. Single constitution for both the center and the states. D. Dominance of legal luminaries in the Constituent Assembly. The Constitution contains not only the fundamental principles of governance, but also detailed administrative provisions. Further, those matters which in other modern democratic countries have been left to the ordinary legislation or established political conventions have also been included in the constitutional document itself in India. 2. Drawn from various sources, the Constitution of India has borrowed most of its provisions from the constitutions of various other countries as well as from the Government of India Act of 1935. Dr. B.R. Ambedkar proudly acclaimed that the Constitution of India has been framed after ransacking all the known constitutions of the world. The structural part of the Constitution is, to a large extent, derived from the Government of India Act of 1935. The philosophical part of the Constitution, the fundamental rights and the directive principles of state policy, derive their inspiration from the American and Irish constitutions, respectively. The political part of the Constitution, the principle of cabinet government and the relations between the executive and the legislature, have been largely drawn from the British Constitution. The other provisions of the Constitution have been drawn from the constitutions of Canada, Australia, Germany, USSR, now Russia, France, South Africa, Japan and so on. The most profound influence and material source of the Constitution is the Government of India Act, 1935. The federal scheme, judiciary, governors, emergency powers, the public service commissions and most of the administrative details are drawn from this act. More than half of the provisions of Constitution are identical to or bear a close resemblance to the Act of 1935. 3. Blend of rigidity and flexibility. Constitutions are also classified into rigid and flexible. A rigid constitution is one that requires a special procedure for its amendment, as for example, the American Constitution. A flexible constitution, on the other hand, is one that can be amended in the same manner as the ordinary laws are made, as for example, the British Constitution. The Constitution of India is neither rigid nor flexible, but a synthesis of both. Article 368 provides for 2 types of amendments. A. Some provisions can be amended by a special majority of the Parliament, that is, a 2/3 majority of the members of each House present and voting, and a majority of the total membership of each House. B. Some other provisions can be amended by a special majority of the Parliament and with the ratification by half of the total states. At the same time, some provisions of the Constitution can be amended by a simple majority of the Parliament in the manner of ordinary legislative process. Notably, these amendments do not come under Article 368. 4. Federal system with unitary bias. The Constitution of India establishes a federal system of government. It contains all the usual features of a federation: two-government, division of powers, written constitution, supremacy of constitution, rigidity of constitution, independent judiciary and bicameralism. However, The Indian constitution also contains a large number of unitary or non-federal features: a strong center, single constitution, single citizenship, flexibility of constitution, integrated judiciary, appointment of state governor by the center, all India services, emergency provisions, and so on. Moreover, the term federation has nowhere been used in the Constitution. Article 1, on the other hand, describes India as a union of states, which implies two things. 1. Indian federation is not the result of an agreement by the states, and 2. No state has the right to secede from the federation. Hence, the Indian constitution has been variously described as federal in form but unitary in spirit, quasi-federal by K.C. Ware, bargaining federalism by Morris Jones, cooperative federalism by Granville Austin, federation with a centralizing tendency by Ivor Jennings, and so on. 5. Parliamentary form of government. The Constitution of India has opted for the British parliamentary system of government rather than American presidential system of government. The parliamentary system is based on the executive organs, while the presidential system is based on the doctrine of separation of powers between the two organs. The parliamentary system is also known as the Westminster model of government, responsible government, and cabinet government. The Constitution establishes the parliamentary system not only at the center, but also in the states. The features of parliamentary government in India are: A. Presence of nominal and real executives. B. Majority party rule. C. Collective responsibility of the executive to the legislature. D. Membership of the ministers in the legislature. E. Leadership of the Prime Minister or the Chief Minister. F. Dissolution of the lower house, Lok Sabha or Assembly. Even though the Indian parliamentary system is largely based on the British pattern, there are some fundamental differences between the two. For example, the Indian Parliament is not a sovereign body like the British Parliament. Further, the Indian state has an elected head, republic, while the British state has hereditary head, monarchy. In a parliamentary system, whether in India or Britain, the role of the Prime Minister has become so significant and crucial that the political scientists like to call it a prime ministerial government. 6. Synthesis of parliamentary sovereignty and judicial supremacy. The doctrine of sovereignty of Parliament is associated with the British Parliament, while the principle of judicial supremacy with that of the American Supreme Court. Just as the Indian parliamentary system differs from the British system, the scope of judicial review power of the Supreme Court in India is narrower than that of what exists in U.S. This is because the American Constitution provides for due process of law against that of procedure established by law contained in the Indian Constitution, Article 21. Therefore, the framers of the Indian Constitution have preferred a proper synthesis between the British principle of parliamentary sovereignty and the American principle of judicial supremacy. The Supreme Court, on the one hand, can declare the parliamentary laws as unconstitutional through its power of judicial review. The Parliament, on the other hand, can amend the major portion of the Constitution through its constituent power. 7. Integrated and independent judiciary. The Indian Constitution establishes a judicial system that is integrated as well as independent. The Supreme Court stands at the top of the integrated judicial system in the country. Below it, there are high courts at the state level. Under a high court, there is a hierarchy of subordinate courts, that is, district courts and other lower courts. This single system of courts enforces both the central laws as well as the state laws, unlike in USA, where the federal laws are enforced by the federal judiciary and the state laws are enforced by the state judiciary. The Supreme Court is a federal court, the highest court of appeal, the guarantor of the fundamental rights of the citizens and the guardian of the Constitution. Hence, The Constitution has made various provisions to ensure its independence, security of tenure of the judges, fixed service conditions for the judges, all the expenses of the Supreme Court charged on the Consolidated Fund of India, prohibition on discussion on the conduct of judges in the legislatures, ban on practice after retirement, power to punish for its contempt vested in the Supreme Court, separation of the judiciary from the executive, and so on. 8. Fundamental rights. Part 3 of the Indian Constitution guarantees 6 fundamental rights to all the citizens. A. Right to equality. Articles 14 to 18. B. Right to freedom. Articles 19 to 22. C. Right against exploitation. Articles 23 to 24. D. Right to freedom of religion. Articles 25 to 28. E. Cultural and educational rights. Articles 29 to 30. And F. Right to constitutional remedies. Article 32. The fundamental rights are meant for promoting the idea of political democracy. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. They are justiciable in nature, that is, they are enforceable by the courts for their violation. The aggrieved person can directly go to the Supreme Court, which can issue the writs of habeas corpus, mandamus, prohibition, certiorari and quo warranto for the restoration of his rights. However, the fundamental rights are not absolute and subject to reasonable restrictions. Further, they are not sacrosanct and can be curtailed or repealed by the Parliament through a Constitutional Amendment Act. They can also be suspended during the operation of a national emergency except the rights guaranteed by Articles 20 and 21. 9. Directive Principles of State Policy. According to Dr. B.R. Ambedkar, the Directive Principles of State Policy is a novel feature of the Indian Constitution. They are enumerated in Part 4 of the Constitution. They can be classified into 3 broad categories: socialistic, Gandhian and liberal intellectual. The directive principles are meant for promoting the ideal of social and economic democracy. They seek to establish a welfare state in India. However, unlike the fundamental rights, the directives are non-justiciable in nature, that is, they are not enforceable by the courts for their violation. Yet, the Constitution itself declares that these principles are fundamental in the governance of the country, and it shall be the duty of the state to apply these principles in making laws. Hence, they impose a moral obligation on the state authorities for their application. But, the real force, sanction, behind them is political, that is, public opinion. In the Minerva Mill case, 1980, the Supreme Court held that the Indian Constitution is founded on the bedrock of the balance between the fundamental rights and the directive principles. 10. Fundamental duties. The original Constitution did not provide for the fundamental duties of the citizens. These were added during the operation of internal emergency, 1975-77 by the 42nd Constitutional Amendment Act of 1976 on the recommendation of the Swaran Singh Committee. The 86th Constitutional Amendment Act of 2002 added one more fundamental duty. The Part 4A of the Constitution, which consists of only one Article 51A, specifies the 11 fundamental duties to respect the Constitution, national flag and national anthem, to protect the sovereignty, unity and integrity of the country, to promote the spirit of common brotherhood amongst all the people, to preserve the rich heritage of our composite culture and so on. The fundamental duties serve as a reminder to citizens that while enjoying their rights, they have also to be quite conscious of duties they owe to their country, their society and to their fellow citizens. However, like the directive principles, the duties are also non-justiciable in nature. 11. A secular state. The Constitution of India stands for a secular state. Hence, It does not uphold any particular religion as the official religion of the Indian state. The following provisions of the Constitution reveal the secular character of the Indian state. A. The term secular was added to the preamble of the Indian Constitution by the 42nd Constitutional Amendment Act of 1976. B. The preamble secures to all citizens of India liberty of belief, faith and worship. C. The state shall not deny to any person equality before the law or equal protection of the laws, Article 14. D. The state shall not discriminate against any citizen on the ground of religion, Article 15. E. Equality of opportunity for all citizens in matters of public employment, Article 16. F. All persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate any religion, Article 25. G. Every religious denomination or any of its sections shall have the right to manage its religious affairs, Article 26. H. No person shall be compelled to pay any taxes for the promotion of a particular religion, Article 27. I. No religious instruction shall be provided in any educational institution maintained by the state, Article 28. J. Any section of the citizens shall have the right to conserve its distinct language, script or culture, Article 29. K. All minorities shall have the right to establish and administer educational institutions of their choice, Article 30. L. The state shall endeavor to secure for all the citizens a uniform civil code, Article 44. The Western concept of secularism connotes a complete separation between the religion, the church, and the state, the politics. This negative concept of secularism is inapplicable in the Indian situation where the society is multi-religious. Hence, the Indian Constitution embodies the positive concept of secularism, giving equal respect to all religions or protecting all religions equally. Moreover, the Constitution has also abolished the old system of communal representation, that is, reservation of seats in the legislatures on the basis of religion. However, it provides for the temporary reservation of seats for the scheduled castes and scheduled tribes to ensure adequate representation to them. 12. Universal adult franchise. The Indian Constitution adopts universal adult franchise as a basis of elections to the Lok Sabha and the state legislative assemblies. Every citizen who is not less than 18 years of age has a right to vote without any discrimination of caste, race, religion, sex, literacy, wealth and so on. The voting age was reduced to 18 years from 21 years in 1989 by the 61st Constitutional Amendment Act of 1988. The introduction of universal adult franchise by the Constitution makers was a bold experiment and highly remarkable in view of the vast size of the country, its huge population, high poverty, social inequality and overwhelming illiteracy. Universal adult franchise makes democracy broad-based, enhances the self-respect and prestige of the common people, upholds the principle of equality, enables minorities to protect their interests and opens up new hopes and vistas for weaker sections. 13. Single citizenship. Though the Indian Constitution is federal and envisages a dual polity, center and states, it provides for only a single citizenship, that is, the Indian citizenship. In countries like USA, on the other hand, each person is not only a citizen of USA, but also a citizen of the particular state to which he belongs. Thus, he owes allegiance to both and enjoys dual sets of rights, one conferred by the national government and another by the state government. In India, all citizens irrespective of the state in which they are born or reside enjoy the same political and civil rights of citizenship all over the country and no discrimination is made between them. Despite the constitutional provision for a single citizenship and uniform rights for all the people, India has been witnessing the communal riots, class conflicts, caste wars, linguistic clashes and ethnic disputes. This means that the cherished goal of the constitution makers to build a united and integrated Indian nation has not been fully realized. 14. Independent bodies. The Indian constitution not only provides for the legislative, executive and judicial organs of the government, central and state, but also establishes certain independent bodies. They are envisaged by the Constitution as the bulwarks of the democratic system of government in India. These are a. Election Commission to ensure free and fair elections to the Parliament, the state legislatures, the Office of President of India, and the Office of Vice President of India. b. Comptroller and Auditor General of India to audit the accounts of the central and state governments. He acts as guardian of public purse and comments on the legality and propriety of government expenditure. c. Union Public Service Commission to conduct examinations for recruitment to all India services and higher central services, and to advise the President on disciplinary matters. The Constitution ensures the independence of these bodies, through various provisions like security of tenure, fixed service, conditions, expenses being charged on the Consolidated Fund of India, and so on. 15. Emergency provisions. The Indian Constitution contains elaborate emergency provisions to enable the President to meet any extraordinary situation effectively. The rationality behind the incorporation of these provisions is to safeguard the sovereignty, unity, integrity and security of the country, the democratic political system and the Constitution. The Constitution envisages three types of emergencies, namely, a. National emergency on the ground of war or external aggression or armed rebellion, Article 352. b. State emergency, President's rule, on the ground of failure of constitutional machinery in the states, Article 356, or failure to comply with the directions of the Center, Article 365, and c. Financial emergency on the ground of threat to the financial stability or credit of India, Article 360. During an emergency, the central government becomes all-powerful and the states go into the total control of the center. It converts the federal structure into a unitary one without a formal amendment of the Constitution. This kind of transformation of the political system from federal, during normal times, to unitary, during emergency, is a unique feature of the Indian Constitution. 16. Three-tier government. Originally, the Indian Constitution, like any other federal constitution, provided for a dual polity and contained provisions with regard to the organization and powers of the center and the states. Later, the 73rd and 74th Constitutional Amendment Acts, 1992, have added a third tier of government, local, which is not found in any other constitution of the world. The 73rd Amendment Act of 1992 gave constitutional recognition to the panchayats, rural local governments, by adding a new Part 9 and a new Schedule 11 to the Constitution. Similarly, the 74th Amendment Act of 1992 gave constitutional recognition to the municipalities, urban local governments, by adding a new Part 9A and a new Schedule 12 to the Constitution. 17. Cooperative societies. The 97th Constitutional Amendment Act of 2011 gave a constitutional status and protection to cooperative societies. In this context, it made the following three changes in the Constitution. 1. It made the right to form cooperative societies a fundamental right, Article 19. 2. It included a new directive principle of state policy on promotion of cooperative societies, Article 43b. 3. It added a new Part 9b in the Constitution which is entitled as the Cooperative Societies, Articles 243zh to 243zt. The new Part 9b contains various provisions to ensure that the cooperative societies in the country function in a democratic, professional, autonomous and economically sound manner. It empowers the Parliament in respect of multi-state cooperative societies and the state legislatures in respect of other cooperative societies to make the appropriate law. Criticism of the Constitution. The Constitution of India, as framed and adopted by the Constituent Assembly of India, has been criticized on the following grounds. 1. A borrowed constitution. The critics opine that the Indian constitution contains nothing new and original. They described it as a borrowed constitution or a bag of borrowings or a hodgepodge constitution or a patchwork of several documents of the world constitutions. However, this criticism is unfair and illogical. This is because the framers of the Constitution made necessary modifications in the features borrowed from other constitutions for their suitability to the Indian conditions, at the same time avoiding their faults. While answering the above criticism in the Constituent Assembly, Dr. B.R. Ambedkar, the chairman of the drafting committee, said, "One likes to ask whether there can be anything new in a constitution framed at this hour in the history of the world. More than 100 years have rolled over when the first written constitution was drafted. It has been followed by many countries reducing their constitutions to writing. What the scope of a constitution should be has long been settled. Similarly, what are the fundamentals of a constitution are recognized all over the world. Given these facts, all constitutions and their main provisions must look similar. The only new things, if there can be any, in a constitution framed so late in the day are the variations made to remove the faults and to accommodate it to the needs of the country. The charge of producing a blind copy of the constitutions of other countries is based, I am sure, on an inadequate study of the Constitution. 2. A carbon copy of the 1935 Act. The critics said that the framers of the Constitution have included a large number of the provisions of the Government of India Act of 1935 into the Constitution of India. Hence, they call the Constitution as a carbon copy of the 1935 Act or an amended version of the 1935 Act. For example, N. Srinivasan observed that the Indian Constitution is both in language and substance a close copy of the Act of 1935. Similarly, Sir Ivor Jennings, a British constitutionalist, said that the Constitution derives directly from the Government of India Act of 1935 from which, in fact, many of its provisions are copied almost textually. Further, P.R. Deshmukh, a member of the Constituent Assembly, commented that the Constitution is essentially the Government of India Act of 1935 with only adult franchise added. The same Dr. B.R. Ambedkar answered the above criticism in the Constituent Assembly in the following way, as to the accusation that the draft Constitution has reproduced a good part of the provisions of the Government of India Act, 1935, I make no apologies. There is nothing to be ashamed of in borrowing. It involves no plagiarism. Nobody holds any patent rights in the fundamental ideas of a constitution. What I am sorry about is that the provisions taken from the Government of India Act, 1935, relate mostly to the details of administration. 3. Un-Indian or anti-Indian. According to the critics, the Indian Constitution is un-Indian or anti-Indian because it does not reflect the political traditions and the spirit of India. They said that the foreign nature of the Constitution makes it unsuitable to the Indian situation or unworkable in India. In this context, K. Hanumanthaya, a member of the Constituent Assembly, commented, "We wanted the music of veena or sitar, but here we have the music of an English band. That was because our constitution makers were educated that way." Similarly, Lokanath Misra, another member of the Constituent Assembly, criticized the Constitution as a slavish imitation of the West, much more, a slavish surrender to the West. Further, Laxminarayan Sahu, also a member of the Constituent Assembly, observed, "The ideals on which this draft constitution is framed have no manifest relation to the fundamental spirit of India. This constitution would not prove suitable and would break down soon after being brought into operation." 4. An un-Gandhian constitution. According to the critics, the Indian constitution is un-Gandhian because it does not contain the philosophy and ideals of Mahatma Gandhi, the father of the Indian nation. They opined that the constitution should have been raised and built upon village panchayats and district panchayats. In this context, the same member of the Constituent Assembly, K. Hanumanthaya, said, "That is exactly the kind of constitution Mahatma Gandhi did not want and did not envisage." T. Prakasam, another member of the Constituent Assembly, attributed this lapse to Ambedkar's non-participation in the Gandhian movement and the antagonism towards the Gandhian ideas. 5. Elephantine size. The critics stated that the Indian constitution is too bulky and too detailed and contains some unnecessary elements. Sir Ivor Jennings, a British constitutionalist, observed that the provisions borrowed were not always well selected and that the constitution, generally speaking, was too long and complicated. In this context, H. V. Kama, a member of the Constituent Assembly, commented, "The emblem and crest that we have selected for our assembly is an elephant. It is perhaps in consonance with that our constitution too is the bulkiest that the world has produced." He also said, "I am sure, the House does not agree that we should make the constitution an elephantine one." 6. Paradise of the lawyers. According to the critics, the Indian constitution is too legalistic and very complicated. They opined that the legal language and phraseology adopted in the Constitution makes it a complex document. The same Sir Ivor Jennings called it a lawyer's paradise. In this context, H. K. Maheshwari, a member of the Constituent Assembly, observed, "The draft tends to make people more litigious, more inclined to go to law courts, less truthful and less likely to follow the methods of truth and nonviolence. If I may say so, the draft is really a lawyer's paradise. It opens up vast avenues of litigation and will give our able and ingenious lawyers plenty of work to do." Similarly, P. R. Deshmukh, another member of the Constituent Assembly, said, "I should, however, like to say that the draft of the articles that have been brought before the House by Dr. Ambedkar seems to my mind to be far too ponderous, like the ponderous tomes of a law manual. A document dealing with a constitution hardly uses so much of padding and so much of verbiage. Perhaps it is difficult for them to compose a document which should be, to my mind, not a law manual but a socio-political document, a vibrating, pulsating and life-giving document. But, to our misfortune, that was not to be, and we have been burdened with so much of words which could have been very easily eliminated." Thank you so much for watching this video. If this audiobook helped you in any way, so please do like and share this video and please hit the subscribe button. Laxmikanth, Indian Polity. Part 1, Chapter 4, Preamble of the Constitution. The American Constitution was the first to begin with a preamble. Many countries, including India, followed this practice. The term preamble refers to the introduction or preface to the Constitution. It contains the summary or essence of the Constitution. N. A. Palkhivala, an eminent jurist and constitutional expert, called the preamble as the identity card of the Constitution. The preamble to the Indian Constitution is based on the Objectives Resolution, drafted and moved by Pandit Nehru and adopted by the Constituent Assembly. It has been amended by the 42nd Constitutional Amendment Act, 1976, which added 3 new words: socialist, secular, and integrity. Text of the Preamble. The Preamble in its present form reads, "We, the people of India, having solemnly resolved to constitute India into a sovereign socialist secular democratic republic and to secure to all its citizens, justice, social, economic and political, liberty of thought, expression, belief, faith and worship, equality of status and of opportunity, and to promote among them all, fraternity assuring the dignity of the individual and the unity and integrity of the nation, in our Constituent Assembly this 26th day of November, 1949, do hereby adopt, enact and give to ourselves this Constitution." Ingredients of the Preamble. The Preamble reveals 4 ingredients or components. 1. Source of authority of the Constitution. The Preamble states that the Constitution derives its authority from the people of India. 2. Nature of Indian state. It declares India to be of a sovereign, socialist, secular democratic and republican polity. 3. Objectives of the Constitution. It specifies justice, liberty, equality and fraternity as the objectives. 4. Date of adoption of the Constitution. It stipulates November 26, 1949, as the date. Keywords in the Preamble. Certain keywords: sovereign, socialist, secular, democratic, republic, justice, liberty, equality and fraternity are explained as follows. 1. Sovereign. The word sovereign implies that India is neither a dependency nor a dominion of any other nation, but an independent state. There is no authority above it, and it is free to conduct its own affairs, both internal and external. Though in 1949, India declared the continuation of her full membership of the Commonwealth of Nations and accepted the British Crown as the head of the Commonwealth, this extra-constitutional declaration does not affect India's sovereignty in any manner. Further, India's membership of the United Nations Organization, UNO, also in no way constitutes a limitation on her sovereignty. Being a sovereign state, India can either acquire a foreign territory or cede a part of its territory in favor of a foreign state. 2. Socialist. Even before the term was added by the 42nd Amendment in 1976, the Constitution had a socialist content in the form of certain directive principles of state policy. In other words, what was hitherto implicit in the Constitution has now been made explicit. Moreover, the Congress Party itself adopted a resolution to establish a socialistic pattern of society in its Avadi session as early as in 1955 and took measures accordingly. Notably, the Indian brand of socialism is a democratic socialism and not a communistic socialism, also known as state socialism, which involves the nationalization of all means of production and distribution and the abolition of private property. Democratic socialism, on the other hand, holds faith in a mixed economy where both public and private sectors coexist side by side. As the Supreme Court says, democratic socialism aims to end poverty, ignorance, disease and inequality of opportunity. Indian socialism is a blend of Marxism and Gandhism, leaning heavily towards the Gandhian socialism. The new economic policy, 1991, of liberalization, privatization and globalization has, however, diluted the socialist credentials of the Indian state. 3. Secular. The term secular too was added by the 42nd Constitutional Amendment Act of 1976. However, as the Supreme Court said in 1974, although the words secular state were not expressly mentioned in the Constitution, there can be no doubt that Constitution makers wanted to establish such a state, and accordingly Articles 25 to 28, guaranteeing the fundamental right to freedom of religion, have been included in the Constitution. The Indian Constitution embodies the positive concept of secularism. All religions in our country, irrespective of their strength, have the same status and support from the state. 4. Democratic. A democratic polity, as stipulated in the preamble, is based on the doctrine of popular sovereignty, that is, possession of supreme power by the people. Democracy is of two types: direct and indirect. In direct democracy, the people exercise their supreme power directly, as is the case in Switzerland. There are 4 devices of direct democracy, namely, referendum, initiative, recall, and plebiscite. In indirect democracy, on the other hand, the representatives elected by the people exercise the supreme power and thus carry on the government and make the laws. This type of democracy, also known as representative democracy, is of two kinds: parliamentary and presidential. The Indian constitution provides for representative parliamentary democracy, under which the executive is responsible to the legislature for all its policies and actions. Universal adult franchise, periodic elections, rule of law, independence of judiciary, and absence of discrimination on certain grounds are the manifestations of the democratic character of the Indian polity. The term democratic is used in the preamble in the broader sense, embracing not only political democracy but also social and economic democracy. This dimension was stressed by Dr. Ambedkar in his concluding speech in the Constituent Assembly on November 25, 1949, in the following way: political democracy cannot last unless there lies at the base of it social democracy. What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity. The principles of liberty, equality, and fraternity are not to be treated as separate items in a trinity. They form a union of trinity in the sense that to divorce one from the other is to defeat the very purpose of democracy. Liberty cannot be divorced from equality, equality cannot be divorced from liberty. Nor can liberty and equality be divorced from fraternity. Without equality, liberty would produce the supremacy of the few over the many. Equality without liberty would kill individual initiative. In the same context, the Supreme Court observed in 1997 that the Constitution envisions to establish an egalitarian social order, rendering to every citizen social, economic, and political justice in a social and economic democracy of the Bharat Republic. 5. Republic. A democratic polity can be classified into two categories: monarchy and republic. In a monarchy, the head of the state, usually king or queen, enjoys a hereditary position, that is, he comes into office through succession, for example, Britain. In a republic, on the other hand, the head of the state is always elected directly or indirectly for a fixed period, for example, USA. Therefore, the term republic in our preamble indicates that India has an elected head called the president. He is elected indirectly for a fixed period of 5 years. A republic also means two more things: 1. Vesting of political sovereignty in the people and not in a single individual like a king. 2. The absence of any privileged class, and hence all public offices being open to every citizen without any discrimination. 6. Justice. The term justice in the preamble embraces three distinct forms: social, economic, and political, secured through various provisions of fundamental rights and directive principles. Social justice denotes the equal treatment of all citizens without any social distinction based on caste, color, race, religion, sex, and so on. It means absence of privileges being extended to any particular section of the society, and improvement in the conditions of backward classes, SCs, STs, and OBCs, and women. Economic justice denotes the non-discrimination between people on the basis of economic factors. It involves the elimination of glaring inequalities in wealth, income, and property. A combination of social justice and economic justice denotes what is known as distributive justice. Political justice implies that all citizens should have equal political rights, equal access to all political offices and equal voice in the government. The ideal of justice, social, economic and political, has been taken from the Russian Revolution, 1917. 7. Liberty. The term liberty means the absence of restraints on the activities of individuals, and at the same time, providing opportunities for the development of individual personalities. The preamble secures to all citizens of India liberty of thought, expression, belief, faith and worship, through their fundamental rights, enforceable in court of law, in case of violation. Liberty as elaborated in the preamble is very essential for the successful functioning of the Indian democratic system. However, liberty does not mean license to do what one likes, and has to be enjoyed within the limitations mentioned in the Constitution itself. In brief, the liberty conceived by the preamble or fundamental rights is not absolute but qualified. The ideals of liberty, equality and fraternity in our preamble have been taken from the French Revolution, 1789 to 1799. 8. Equality. The term equality means the absence of special privileges to any section of the society, and the provision of adequate opportunities for all individuals without any discrimination. The preamble secures to all citizens of India equality of status and opportunity. This provision embraces three dimensions of equality: civic, political and economic. The following provisions of the chapter on fundamental rights ensure civic equality. A. Equality before the law, Article 14. B. Prohibition of discrimination on grounds of religion, race, caste, sex or place of birth, Article 15. C. Equality of opportunity in matters of public employment, Article 16. D. Abolition of untouchability, Article 17. E. Abolition of titles, Article 18. There are two provisions in the Constitution that seek to achieve political equality. 1. No person is to be declared ineligible for inclusion in electoral rolls on grounds of religion, race, caste or sex, Article 325. 2. Elections to the Lok Sabha and the state assemblies to be on the basis of adult suffrage, Article 326. The directive principles of state policy, Article 39, secures to men and women equal right to an adequate means of livelihood and equal pay for equal work. 9. Fraternity. Fraternity means a sense of brotherhood. The Constitution promotes this feeling of fraternity by the system of single citizenship. Also, the fundamental duties, Article 51A, say that it shall be the duty of every citizen of India to promote harmony and the spirit of common brotherhood amongst all the people of India, transcending religious, linguistic, regional or sectional diversities. The preamble declares that fraternity has to assure two things: the dignity of the individual and the unity and integrity of the nation. The word integrity has been added to the preamble by the 42nd Constitutional Amendment, 1976. According to K.M. Munshi, a member of the drafting committee of the Constituent Assembly, the phrase dignity of the individual signifies that the Constitution not only ensures material betterment and maintain a democratic setup, but that it also recognizes that the personality of every individual is sacred. This is highlighted through some of the provisions of the fundamental rights and directive principles of state policy, which ensure the dignity of individuals. Further, the fundamental duties, Article 51A, also protect the dignity of women by stating that it shall be the duty of every citizen of India to renounce practices derogatory to the dignity of women, and also makes it the duty of every citizen of India to uphold and protect the sovereignty, unity and integrity of India. The phrase unity and integrity of the nation embraces both the psychological and territorial dimensions of national integration. Article 1 of the Constitution describes India as a union of states to make it clear that the states have no right to secede from the union, implying the indestructible nature of the Indian Union. It aims at overcoming hindrances to national integration like communalism, regionalism, casteism, linguism, secessionism, and so on. Significance of the Preamble. The Preamble embodies the basic philosophy and fundamental values political, moral and religious on which the Constitution is based. It contains the grand and noble vision of the Constituent Assembly, and reflects the dreams and aspirations of the Founding Fathers of the Constitution. In the words of Sir Aladi Krishna Swami Iyer, a member of the Constituent Assembly who played a significant role in making the Constitution, the preamble to our Constitution expresses what we had thought or dreamt so long. According to K.M. Munshi, a member of the drafting committee of the Constituent Assembly, the preamble is the horoscope of our sovereign democratic republic. Pandit Thakur Das Bhargava, another member of the Constituent Assembly, summed up the importance of the preamble in the following words: "The preamble is the most precious part of the Constitution. It is the soul of the Constitution. It is a key to the Constitution. It is a jewel set in the Constitution. It is a proper yardstick with which one can measure the worth of the Constitution." Sir Ernest Barker, a distinguished English political scientist, paid a glowing tribute to the political wisdom of the authors of the preamble. He described the preamble as the keynote to the Constitution. He was so moved by the text of the preamble that he quoted it at the opening of his popular book, Principles of Social and Political Theory, 1951. Muhammad Hidayatullah, a former Chief Justice of India, observed, "Preamble resembles the Declaration of Independence of the United States of America, but is more than a declaration. It is the soul of our Constitution, which lays down the pattern of our political society. It contains a solemn resolve, which nothing but a revolution can alter." Preamble as part of the Constitution. One of the controversies about the preamble is as to whether it is a part of the Constitution or not. In the Berubari Union case, 1960, the Supreme Court said that the preamble shows the general purposes behind the several provisions in the Constitution, and is thus a key to the minds of the makers of the Constitution. Further, where the terms used in any article are ambiguous or capable of more than one meaning, some assistance at interpretation may be taken from the objectives enshrined in the preamble. Despite this recognition of the significance of the preamble, the Supreme Court specifically opined that preamble is not a part of the Constitution. In the Keswa Andabarti case, 1973, the Supreme Court rejected the earlier opinion and held that preamble is a part of the Constitution. It observed that the preamble is of extreme importance and the Constitution should be read and interpreted in the light of the grand and noble vision expressed in the preamble. In the LIC of India case, 1995, also, the Supreme Court again held that the preamble is an integral part of the Constitution. Like any other part of the Constitution, the preamble was also enacted by the Constituent Assembly, but after the rest of the Constitution was already enacted. The reason for inserting the preamble at the end was to ensure that it was in conformity with the Constitution as adopted by the Constituent Assembly. While forwarding the preamble for votes, the President of the Constituent Assembly said, "The question is that preamble stands part of the Constitution." The motion was then adopted. Hence, the current opinion held by the Supreme Court that the preamble is a part of the Constitution is in consonance with the opinion of the Founding Fathers of the Constitution. The Founding Fathers of the Constitution. However, two things should be noted. 1. The preamble is neither a source of power to legislature nor a prohibition upon the powers of legislature. 2. It is non-justiciable, that is, its provisions are not enforceable in courts of law. Amenability of the preamble. The question as to whether the preamble can be amended under Article 368 of the Constitution arose for the first time in the historic Kesavananda Bharti case, 1973. It was urged that the preamble cannot be amended as it is not a part of the Constitution. The petitioner contended that the amending power in Article 368 cannot be used to destroy or damage the basic elements or the fundamental features of the Constitution, which are enshrined in the preamble. The Supreme Court, however, held that the preamble is a part of the Constitution. The court stated that the opinion tendered by it in the Berubari Union, 1960, in this regard was wrong, and held that the preamble can be amended, subject to the condition that no amendment is done to the basic features. In other words, the court held that the basic elements or the fundamental features of the Constitution as contained in the preamble cannot be altered by an amendment under Article 368. The preamble has been amended only once so far, in 1976, by the 42nd Constitutional Amendment Act, which has added 3 new words: socialist, secular and integrity to the preamble. This amendment was held to be valid. Thank you so much for watching this video. If this audiobook helped you in any way, so please do like and share this video, and please hit the subscribe button.
Laxmikanth, Indian Polity. Part 1. Chapter 5, Union and its Territory. Articles 1 to 4 under Part 1 of the Constitution deal with the Union and its territory. Union of States. Article 1 describes India, that is, Bharat, as a union of states rather than a federation of states. This provision deals with 2 things: 1. Name of the country, and 2. Type of polity. There was no unanimity in the Constituent Assembly with regard to the name of the country. Some members suggested the traditional name, Bharat, while others advocated the modern name, India. Hence, the Constituent Assembly had to adopt a mix of both. India, that is, Bharat. Secondly, the country is described as union although its constitution is federal in structure. According to Dr. B.R. Ambedkar, the phrase Union of States has been preferred to Federation of States for 2 reasons. 1. The Indian Federation is not the result of an agreement among the states like the American Federation, and 2. The states have no right to secede from the Federation. The Federation is an union because it is indestructible. The country is an integral whole and divided into different states only for the convenience of administration. According to Article 1, the territory of India can be classified into 3 categories. 1. Territories of the states. 2. Union territories. 3. Territories that may be acquired by the Government of India at any time. The names of states and union territories and their territorial extent are mentioned in the first schedule of the Constitution. At present, there are 28 states and 9 union territories. The provisions of the Constitution pertaining to the states are applicable to all the states in the same manner. However, the special provisions under Part 21 applicable to the states of Maharashtra, Gujarat, Nagaland, Assam, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa and Karnataka override the general provisions relating to the states as a class. Further, the 5th and 6th schedules contain separate provisions with respect to the administration of scheduled areas and tribal areas within the states. Notably, the territory of India is a wider expression than the Union of India because the latter includes only states while the former includes not only the states, but also union territories and territories that may be acquired by the Government of India at any future time. The states are the members of the federal system and share a distribution of powers with the center. The union territories and the acquired territories, on the other hand, are directly administered by the central government. Being a sovereign state, India can acquire foreign territories according to the modes recognized by international law, that is, cession, following treaty, purchase, gift, lease or plebiscite, occupation, hitherto unoccupied by a recognized ruler, conquest or subjugation. For example, India acquired several foreign territories such as Dadra and Nagar Haveli, Goa, Daman and Diu, Puducherry, and Sikkim since the commencement of the constitution. The acquisition of these territories are discussed later in this chapter. Article 2 empowers the Parliament to admit into the Union of India or establish new states on such terms and conditions as it thinks fit. Thus, Article 2 grants to powers to the Parliament a. The power to admit into the Union of India new states and b. The power to establish new states. The first refers to the admission of states which are already in existence, while the second refers to the establishment of states which were not in existence before. Notably, Article 2 relates to the admission or establishment of new states that are not part of the Union of India. Article 3, on the other hand, relates to the formation of or changes in the existing states of the Union of India. In other words, Article 3 deals with the internal readjustment inter se of the territories of the constituent states of the Union of India. Parliament's power to reorganize the states. Article 3 authorizes the Parliament to a. Form a new state by separation of territory from any state or by uniting two or more states or parts of states or by uniting any territory to a part of any state. b. Increase the area of any state. c. Diminish the area of any state. d. Alter the boundaries of any state and e. Alter the name of any state. However, Article 3 lays down two conditions in this regard. 1. A bill contemplating the above changes can be introduced in the Parliament only with the prior recommendation of the President, and 2. Before recommending the bill, the President has to refer the same to the state legislature concerned for expressing its views within a specified period. Further, the power of Parliament to form new states includes the power to form a new state or union territory by uniting a part of any state or union territory to any other state or union territory. The President or Parliament is not bound by the views of the state legislature and may either accept or reject them, even if the views are received in time. Further, it is not necessary to make a fresh reference to the state legislature every time an amendment to the bill is moved and accepted in Parliament. In case of a union territory, no reference need be made to the concerned legislature to ascertain its views, and the Parliament can itself take any action as it deems fit. It is, thus, clear that the Constitution authorizes the Parliament to form new states or alter the areas, boundaries or names of the existing states without their consent. In other words, the Parliament can redraw the political map of India according to its will. Hence, the territorial integrity or continued existence of any state is not guaranteed by the Constitution. Therefore, India is rightly described as an indestructible union of destructible states. The union government can destroy the states, whereas the state governments cannot destroy the union. In USA, on the other hand, the territorial integrity or continued existence of a state is guaranteed by the Constitution. The American federal government cannot form new states or alter the borders of existing states without the consent of the states concerned. That is why the USA is described as an indestructible union of indestructible states. Moreover, the Constitution, Article 4, itself declares that laws made for admission or establishment of new states under Article 2 and formation of new states and alteration of areas, boundaries or names of existing states under Articles 3 are not to be considered as amendments of the Constitution under Article 368. This means that such laws can be passed by a simple majority and by the ordinary legislative process. Does the power of Parliament to diminish the areas of a state under Article 3 include also the power to cede Indian territory to a foreign country? This question came up for examination before the Supreme Court in a reference made by the President in 1960. The decision of the central government to cede part of a territory known as Berubri Union, West Bengal, to Pakistan led to political agitation and controversy and thereby necessitated the presidential reference. The Supreme Court held that the power of Parliament to diminish the area of a state under Article 3 does not cover cession of Indian territory to a foreign country. Hence, Indian territory can be ceded to a foreign state only by amending the Constitution under Article 368. Consequently, the 9th Constitutional Amendment Act, 1960, was enacted to transfer the said territory to Pakistan. On the other hand, the Supreme Court in 1969 ruled that settlement of a boundary dispute between India and another country does not require a constitutional amendment. It can be done by executive action as it does not involve cession of Indian territory to a foreign country. Exchange of territories with Bangladesh. The 100th Constitutional Amendment Act, 2015, was enacted to give effect to the acquiring of certain territories by India and transfer of certain other territories to Bangladesh in pursuance of the agreement and its protocol entered into between the governments of India and Bangladesh. Under this deal, India transferred 111 enclaves to Bangladesh, while Bangladesh transferred 51 enclaves to India. In addition, the deal also involved the transfer of adverse possessions and the demarcation of a 6.1 kilometers undemarcated border stretch. For these three purposes, the amendment modified the provisions relating to the territories of 4 states, Assam, West Bengal, Meghalaya and Tripura, in the first schedule of the Constitution. The background of this amendment is as follows. 1. India and Bangladesh have a common land boundary of approximately 4,096.7 kilometers. The Indiaized Pakistan land boundary was determined as per the Ratcliffe Award of 1947. Disputes arose out of some provisions in the Ratcliffe Award, which were sought to be resolved through the Bag Award of 1950. Another effort was made to settle these disputes by the Nehru-Noon Agreement of 1958. However, the issue relating to division of Berubri Union was challenged before the Supreme Court. To comply with the opinion rendered by the Supreme Court, the Constitution, 9th Amendment Act, 1960 was passed by the Parliament. Due to the continuous litigation and other political developments at that time, the Constitution, 9th Amendment Act, 1960 could not be notified in respect of territories in former East Pakistan, presently Bangladesh. 2. On 16 May 1974, the agreement between India and Bangladesh concerning the demarcation of the land boundary and related matters was signed between both the countries to find a solution to the complex nature of the border demarcation involved. This agreement was not ratified as it involved, inter alia, transfer of territory which requires a constitutional amendment. In this connection, it was also required to identify the precise area on the ground which would be transferred. Subsequently, the issues relating to demarcation of undemarcated boundary, the territories in adverse possession, and exchange of enclaves were identified and resolved by signing a protocol on 6 September 2011, which forms an integral part of the land boundary agreement between India and Bangladesh, 1974. The protocol was prepared with support and concurrence of the concerned state governments of Assam, Meghalaya, Tripura and West Bengal. Evolution of states and union territories. Integration of princely states. At the time of independence, India comprised two categories of political units, namely, the British provinces, under the direct rule of British government, and the princely states, under the rule of native princes but subject to the paramountcy of the British Crown. The Indian Independence Act, 1947, created two independent and separate dominions of India and Pakistan and gave three options to the princely states, viz., joining India, joining Pakistan or remaining independent. Of the 552 princely states situated within the geographical boundaries of India, 549 joined India and the remaining three, Hyderabad, Junagadh and Kashmir, refused to join India. However, in course of time, they were also integrated with India, Hyderabad by means of police action, Junagadh by means of referendum and Kashmir by the instrument of accession. In 1950, the Constitution contained a fourfold classification of the states and territories of the Indian Union, Part A, Part B and Part C states and Part D territories. In all, they numbered 29. Part A states comprised 9 erstwhile governors' provinces of British India. Part B states consisted of 9 erstwhile princely states with legislatures. Part C states consisted of erstwhile chief commissioners' provinces of British India and some of the erstwhile princely states. These Part C states, in all 10 in number, were centrally administered. The Andaman and Nicobar Islands were kept as the solitary Part D territories. Dhar Commission and JVP Committee. The integration of princely states with the rest of India has purely an ad hoc arrangement. There has been a demand from different regions, particularly South India, for reorganization of states on linguistic basis. Accordingly, in June 1948, the Government of India appointed the Linguistic Provinces Commission under the chairmanship of S.K. Dhar to examine the feasibility of this. The Commission submitted its report in December 1948 and recommended the reorganization of states on the basis of administrative convenience rather than linguistic factor. This created much resentment and led to the appointment of another Linguistic Provinces Committee by the Congress in December 1948 itself to examine the whole question afresh. It consisted of Jawaharlal Nehru, Vallabhbhai Patel and Pattabhi Sitarmaya and hence was popularly known as JVP Committee 6. It submitted its report in April 1949 and formally rejected language as the basis for reorganization of states. Thank you so much for watching this video. If you want to buy this book, then link in the description, you can buy it from there. If this video helped you in any way, so please do like and share this video and hit the subscribe button. Laxmikanth Chapter 5 Part 2 Union and its Territory. However, in October 1953, the Government of India was forced to create the first linguistic state, known as Andhra State, by separating the Telugu-speaking areas from the Madras state. This followed a prolonged popular agitation and the death of Potti Sriramulu, a Congress person of standing, after a 56-day hunger strike for the cause. Fazl Ali Commission. The creation of Andhra state intensified the demand from other regions for creation of states on linguistic basis. This forced the Government of India to appoint, in December 1953, a 3-member States Reorganization Commission under the chairmanship of Fazl Ali to re-examine the whole question. Its other 2 members were K.M. Panikkar and H.N. Kunzaru. It submitted its report in September 1955 and broadly accepted language as the basis of reorganization of states. But it rejected the theory of one language, one state. Its view was that the unity of India should be regarded as the primary consideration in any redrawing of the country's political units. It identified 4 major factors that can be taken into account in any scheme of reorganization of states. A. preservation and strengthening of the unity and security of the country. B. Linguistic and cultural homogeneity. C. Financial, economic and administrative considerations. D. Planning and promotion of the welfare of the people in each state as well as of the nation as a whole. The Commission suggested the abolition of the fourfold classification of states and territories under the original constitution and creation of 16 states and 3 centrally administered territories. The Government of India accepted these recommendations with certain minor modifications. By the States Reorganization Act, 1956, and the 7th Constitutional Amendment Act, 1956, the distinction between Part A and Part B states was done away with and Part C states were abolished. Some of them were merged with adjacent states and some other were designated as union territories. As a result, 14 states and 6 union territories were created on 1 November 1956. The States Reorganization Act, 1956, established the new state of Kerala by merging the Travancore, Cochin state with the Malabar district of Madras state and Kasaragod of South Kannada, Dakshina Kannada. It merged the Telugu-speaking areas of Hyderabad state with the Andhra state to create the Andhra Pradesh state. Further, it merged the Madhya Bharat state, Vindhya Pradesh state and Bhopal state into the Madhya Pradesh state. Similarly, it merged the Saurashtra state and Kutch state into that of the Bombay state, the Coorg state into that of Mysore state, the Patiala and East Punjab states union, PEPSU, into that of Punjab state, and the Ajmer state into that of Rajasthan state. Moreover, it created the new union territory of Lakkadiv, Minikoi and Amindivi Islands from the territory detached from the Madras state. New states and union territories created after 1956. Even after the large-scale reorganization of the states in 1956, the political map of India underwent continuous changes due to the pressure of popular agitations and political conditions. The demand for the creation of some more states on the basis of language or cultural homogeneity resulted in the bifurcation of existing states. Maharashtra and Gujarat. In 1960, the bilingual state of Bombay was divided into 2 separate states, Maharashtra for Marathi-speaking people and Gujarat for Gujarati-speaking people. Gujarat was established as the 15th state of the Indian Union. Dadra and Nagar Haveli. The Portuguese ruled this territory until its liberation in 1954. Subsequently, the administration was carried on till 1961 by an administrator chosen by the people themselves. It was converted into a union territory of India by the 10th Constitutional Amendment Act, 1961. Goa, Daman and Diu. India acquired these 3 territories from the Portuguese by means of a police action in 1961. They were constituted as a union territory by the 12th Constitutional Amendment Act, 1962. Later, in 1987, Goa was conferred a statehood. Consequently, Daman and Diu was made a separate union territory. Puducherry. The territory of Puducherry comprises the former French establishments in India known as Puducherry, Karaikal, Mahe and Yanam. The French handed over this territory to India in 1954. Subsequently, it was administered as an acquired territory till 1962 when it was made a union territory by the 14th Constitutional Amendment Act. Nagaland. In 1963, the state of Nagaland was formed by taking the Naga Hills and Tuensang area out of the state of Assam. This was done to satisfy the movement of the hostile Nagas. However, before giving Nagaland the status of the 16th state of the Indian Union, it was placed under the control of Governor of Assam in 1961. Haryana, Chandigarh and Himachal Pradesh. In 1966, the state of Punjab was bifurcated to create Haryana, the 17th state of the Indian Union, and the Union Territory of Chandigarh. This followed the demand for a separate Sikh homeland, Punjabi Subha, raised by the Akali Dal under the leadership of Master Tara Singh. On the recommendation of the Shah Commission, 1966, the Punjabi-speaking areas were constituted into the unilingual state of Punjab, the Hindi-speaking areas were constituted into the state of Haryana, and the hill areas were merged with the adjoining Union Territory of Himachal Pradesh. In 1971, the Union Territory of Himachal Pradesh was elevated to the status of a state, 18th state of the Indian Union. Manipur, Tripura and Meghalaya. In 1972, the political map of northeast India underwent a major change. Thus, the two union territories of Manipur and Tripura and the sub-state of Meghalaya got statehood, and the two union territories of Mizoram and Arunachal Pradesh, originally known as Northeast Frontier Agency (NEFA), came into being. With this, the number of states of the Indian Union increased to 21, Manipur 19th, Tripura 20th and Meghalaya 21st. Initially, the 22nd Constitutional Amendment Act, 1969, created Meghalaya as an autonomous state or sub-state within the state of Assam with its own legislature and council of ministers. However, this did not satisfy the aspirations of the people of Meghalaya. The union territories of Mizoram and Arunachal Pradesh were also formed out of the territories of Assam. Sikkim. Till 1947, Sikkim was an Indian princely state ruled by Chogyal. In 1947, after the lapse of British paramountcy, Sikkim became a protectorate of India, whereby the Indian government assumed responsibility for the defence, external affairs and communications of Sikkim. In 1974, Sikkim expressed its desire for greater association with India. Accordingly, the 35th Constitutional Amendment Act, 1974, was enacted by the Parliament. This amendment introduced a new class of statehood under the Constitution by conferring on Sikkim the status of an associate state of the Indian Union. For this purpose, a new Article 2-A and a new schedule, 10th schedule containing the terms and conditions of association, were inserted in the Constitution. This experiment, however, did not last long as it could not fully satisfy the aspirations of the people of Sikkim. In a referendum held in 1975, they voted for the abolition of the institution of Chogyal and Sikkim becoming an integral part of India. Consequently, the 36th Constitutional Amendment Act, 1975, was enacted to make Sikkim a full-fledged state of the Indian Union, the 22nd state. This amendment amended the first and the fourth schedules to the Constitution and added a new Article 371-F to provide for certain special provisions with respect to the administration of Sikkim. It also repealed Article 2-A and the 10th schedule that were added by the 35th Amendment Act of 1974. Mizoram, Arunachal Pradesh and Goa. In 1987, 3 new states of Mizoram, 14 Arunachal Pradesh 15 and Goa 16 came into being as the 23rd, 24th and 25th states of the Indian Union respectively. The Union Territory of Mizoram was conferred the status of a full state as a sequel to the signing of a Memorandum of Settlement, Mizoram Peace Accord, in 1986 between the central government and the Mizo National Front, ending the 2-decade-old insurgency. Arunachal Pradesh had also been a union territory from 1972. The state of Goa was created by separating the territory of Goa from the Union Territory of Goa, Daman and Diu. Chhattisgarh, Uttarakhand and Jharkhand. In 2000, 3 more new states of Chhattisgarh, Uttarakhand and Jharkhand were created out of the territories of Madhya Pradesh, Uttar Pradesh and Bihar, respectively. These became the 26th, 27th, and 28th states of the Indian Union, respectively. Telangana. In 2014, the new state of Telangana came into existence as the 29th state of the Indian Union. It was carved out of the territories of Andhra Pradesh. The Andhra State Act, 1953, formed the first linguistic state of India, known as the state of Andhra, by taking out the Telugu-speaking areas from the state of Madras, now Tamil Nadu. Kurnool was the capital of Andhra state, and the state high court was established at Guntur. The States Reorganization Act, 1956, merged the Telugu-speaking areas of Hyderabad state with the Andhra state to create the enlarged Andhra Pradesh state. The capital of the state was shifted to Hyderabad. Again, the Andhra Pradesh Reorganization Act, 2014, bifurcated the Andhra Pradesh into two separate states, namely, the Andhra Pradesh, residuary, and the Telangana. Jammu and Kashmir and Ladakh. Till 2019, the erstwhile state of Jammu and Kashmir had its own constitution and thus enjoyed a special status by virtue of Article 370 of the Constitution of India. In 2019, this special status was abolished by a presidential order known as the Constitution, Application to Jammu and Kashmir, Order, 2019. This order superseded the earlier order known as the Constitution, Application to Jammu and Kashmir, Order, 1954. The 2019 order extended all the provisions of the Constitution of India to Jammu and Kashmir also. However, the inoperative Article 370 continued to remain in the text of the Constitution of India. Further, the Jammu and Kashmir Reorganization Act, 2019, bifurcated the erstwhile state of Jammu and Kashmir into two separate union territories, namely, the Union Territory of Jammu and Kashmir and the Union Territory of Ladakh. The Union Territory of Jammu and Kashmir comprises all the districts of the erstwhile state of Jammu and Kashmir except the Kargil and Leh districts which have gone to the Union Territory of Ladakh. Thus, the number of states and union territories increased from 14 and 6 in 1956 to 28 and 9 in 2019, respectively. Change of names. The names of some states and union territories have also been changed. The United Provinces was the first state to have a new name. It was renamed Uttar Pradesh in 1950. In 1969, Madras was renamed Tamil Nadu. Similarly, in 1973, Mysore was renamed Karnataka. In the same year, Laxmikanth, Minikoy and Amindivi Islands were renamed Lakshadweep. In 1992, the Union Territory of Delhi was redesignated as the National Capital Territory of Delhi, without being conferred the status of a full-fledged state, by the 69th Constitutional Amendment Act, 1991. In 2006, Uttaranchal was renamed as Uttarakhand. In the same year, Pondicherry was renamed as Puducherry. In 2011, Odisha was renamed as Odisha. Thank you so much for watching this video. If you want to buy this book, then link in the description, you can buy it from there. If this video helped you in any way, so please do like and share this video and hit the subscribe button. M. Laxmikanth, Indian Polity. Part 1. Chapter 6. Citizenship, Meaning and Significance. Like any other modern state, India has two kinds of people, citizens and aliens. Citizens are full members of the Indian state and owe allegiance to it. They enjoy all civil and political rights. Aliens, on the other hand, are the citizens of some other state and hence do not enjoy all the civil and political rights. They are of two categories. Friendly aliens or enemy aliens. Friendly aliens are the subjects of those countries that have cordial relations with India. Enemy aliens, on the other hand, are the subjects of that country that is at war with India. They enjoy lesser rights than the friendly aliens, aid. They do not enjoy protection against arrest and detention, Article 22. The Constitution confers the following rights and privileges on the citizens of India and denies the same to aliens. 1. Right against discrimination on grounds of religion, race, caste, sex or place of birth, Article 15. 2. Right to equality of opportunity in the matter of public employment, Article 16. 3. Right to freedom of speech and expression, assembly, association, movement, residence and profession, Article 19. 4. Cultural and educational rights, Articles 29 and 30. 5. Right to vote in elections to the Lok Sabha and State Legislative Assembly. 6. Right to contest for the membership of the Parliament and the State Legislature. 7. Eligibility to hold certain public offices, that is, President of India, Vice President of India, Judges of the Supreme Court and the High Courts, Governor of States, Attorney General of India and Advocate General of States. Along with the above rights, the citizens also owe certain duties towards the Indian state, as for example, paying taxes, respecting the national flag and national anthem, defending the country and so on. In India, both a citizen by birth as well as a naturalized citizen are eligible for the office of president, while in USA, only a citizen by birth and not a naturalized citizen is eligible for the office of president. Constitutional provisions. The Constitution deals with the citizenship from Articles 5 to 11 under Part 2. However, it contains neither any permanent nor any elaborate provisions in this regard. It only identifies the persons who became citizens of India at its commencement on 26 January 1950. It does not deal with the problem of acquisition or loss of citizenship subsequent to its commencement. It empowers the Parliament to enact a law to provide for such matters and any other matter relating to citizenship. Accordingly, the Parliament has enacted the Citizenship Act 1955, which has been amended from time to time. According to the Constitution, the following four categories of persons became the citizens of India at its commencement on 26 January 1950. 1. A person who had his domicile in India and also fulfilled any one of the three conditions, viz., if he was born in India, or if either of his parents was born in India, or if he has been ordinarily resident in India for 5 years immediately before the commencement of the Constitution, became a citizen of India. 2. A person who migrated to India from Pakistan became an Indian citizen if he or either of his parents or any of his grandparents was born in undivided India and also fulfilled any one of the two conditions, viz., in case he migrated to India before 19th July 1948, he had been ordinarily resident in India since the date of his migration, or in case he migrated to India on or after 19th July 1948, he had been registered as a citizen of India. But a person could be so registered only if he had been resident in India for 6 months preceding the date of his application for registration. 3. A person who migrated to Pakistan from India after 1st March 1947 but later returned to India for resettlement could become an Indian citizen. For this, he had to be resident in India for 6 months preceding the date of his application for registration. 4. A person who, or any of whose parents or grandparents, was born in undivided India but who is ordinarily residing outside India shall become an Indian citizen if he has been registered as a citizen of India by the diplomatic or consular representative of India in the country of his residence, whether before or after the commencement of the Constitution. Thus, this provision covers the overseas Indians who may want to acquire Indian citizenship. To sum up, these provisions deal with the citizenship of a. persons domiciled in India, b. persons migrated from Pakistan, c. persons migrated to Pakistan but later returned, and d. persons of Indian origin residing outside India. The other constitutional provisions with respect to the citizenship are as follows. 1. No person shall be a citizen of India or be deemed to be a citizen of India if he has voluntarily acquired the citizenship of any foreign state. 2. Every person who is or is deemed to be a citizen of India shall continue to be such citizen, subject to the provisions of any law made by Parliament. 3. Parliament shall have the power to make any provision with respect to the acquisition and termination of citizenship and all other matters relating to citizenship. The Citizenship Act, 1955, provides for acquisition and loss of citizenship after the commencement of the Constitution. Originally, the Citizenship Act, 1955, also provided for the Commonwealth citizenship. But this provision was repealed by the Citizenship Amendment Act, 2003. Acquisition of citizenship. The Citizenship Act of 1955 prescribes 5 ways of acquiring citizenship, viz. Birth, descent, registration, naturalization and incorporation of territory. 1. By birth. A person born in India on or after 26 January 1950 but before 1 July 1987 is a citizen of India by birth irrespective of the nationality of his parents. A person born in India on or after 1 July 1987 is considered as a citizen of India only if either of his parents is a citizen of India at the time of his birth. Further, those born in India on or after 3rd December 2004 are considered citizens of India only if both of their parents are citizens of India or one of whose parents is a citizen of India and the other is not an illegal migrant at the time of their birth. The children of foreign diplomats posted in India and enemy aliens cannot acquire Indian citizenship by birth. 2. By descent. A person born outside India on or after 26 January 1950 but before 10 December 1992 is a citizen of India by descent if his father was a citizen of India at the time of his birth. A person born outside India on or after 10 December 1992 is considered as a citizen of India if either of his parents is a citizen of India at the time of his birth. 3rd December 2004 onwards, a person born outside India shall not be a citizen of India by descent unless his birth is registered at an Indian consulate within 1 year of the date of birth or with the permission of the central government after the expiry of the said period. An application for registration of the birth of a minor child to an Indian consulate shall be accompanied by an undertaking in writing from the parents of such minor child that he or she does not hold the passport of another country. Further, a minor who is a citizen of India by virtue of descent and is also a citizen of any other country shall cease to be a citizen of India if he does not renounce the citizenship or nationality of another country within 6 months of his attaining full age. 3. By registration. The central government may, on an application, register as a citizen of India any person, not being an illegal migrant, if he belongs to any of the following categories, namely, a person of Indian origin who is ordinarily resident in India for 7 years before making an application for registration. B. A person of Indian origin who is ordinarily resident in any country or place outside undivided India. C. A person who is married to a citizen of India and is ordinarily resident in India for 7 years before making an application for registration. D. Minor children of persons who are citizens of India. E. A person of full age and capacity whose parents are registered as citizens of India. F. A person of full age and capacity who, or either of his parents, was earlier citizen of independent India and is ordinarily resident in India for 12 months immediately before making an application for registration. G. A person of full age and capacity who has been registered as an overseas citizen of India cardholder for 5 years and who is ordinarily resident in India for 12 months before making an application for registration. A person shall be deemed to be of Indian origin if he, or either of his parents, was born in undivided India or in such other territory which became part of India after 15th August 1947. All the above categories of persons must take an oath of allegiance before they are registered as citizens of India. 4. By naturalization. The central government may, on an application, grant a certificate of naturalization to any person, not being an illegal migrant, if he possesses the following qualifications. A. That he is not a subject or citizen of any country where citizens of India are prevented from becoming subjects or citizens of that country by naturalization. B. That, if he is a citizen of any country, he undertakes to renounce the citizenship of that country in the event of his application for Indian citizenship being accepted. C. That he has either resided in India or been in the service of a government in India or partly the one and partly the other, throughout the period of 12 months immediately preceding the date of the application. D. That during the 14 years immediately preceding the said period of 12 months, he has either resided in India or been in the service of a government in India, or partly the one and partly the other, for periods amounting in the aggregate to not less than 11 years. E. That he is of good character. F. That he has an adequate knowledge of a language specified in the 8th schedule to the Constitution, and G. That in the event of a certificate of naturalization being granted to him, he intends to reside in India or to enter into or continue in service under a government in India or under an international organization of which India is a member or under a society, company or body of persons established in India. However, the Government of India may waive all or any of the above conditions for naturalization in the case of a person who has rendered distinguished service to the science, philosophy, art, literature, world peace or human progress. Every naturalized citizen must take an oath of allegiance to the Constitution of India. 5. By incorporation of territory. If any foreign territory becomes a part of India, the Government of India specifies the persons who among the people of the territory shall be the citizens of India. Such persons become the citizens of India from the notified date. For example, when Pondicherry became a part of India, the Government of India issued the Citizenship, Pondicherry, Order, 1962 under the Citizenship Act, 1955. 6. Special provisions as to citizenship of persons covered by the Assam Accord. The Citizenship Amendment Act, 1985 added the following special provisions as to citizenship of persons covered by the Assam Accord, which related to the foreigners issue. A. All persons of Indian origin who came to Assam before 1st January 1966 from Bangladesh and who have been ordinarily residents in Assam since the date of their entry into Assam shall be deemed to be citizens of India as from 1st January 1966. B. Every person of Indian origin who came to Assam on or after 1st January 1966 but before 25th March 1971 from Bangladesh and who has been ordinarily resident in Assam since the date of his entry into Assam and who has been detected to be a foreigner shall register himself. Such a registered person shall be deemed to be a citizen of India for all purposes as from the date of expiry of a period of 10 years from the date of detection as a foreigner. But in the intervening period of 10 years, he shall have the same rights and obligations as a citizen of India, excepting the right to vote. Loss of citizenship. The Citizenship Act, 1955, prescribes 3 ways of losing citizenship whether acquired under the Act or prior to it under the Constitution, viz. Renunciation, termination and deprivation. 1. By renunciation. Any citizen of India of full age and capacity can make a declaration renouncing his Indian citizenship. Upon the registration of that declaration, that person ceases to be a citizen of India. However, if such a declaration is made during a war in which India is engaged, its registration shall be withheld by the central government. Further, when a person renounces his Indian citizenship, every minor child of that person also loses Indian citizenship. However, when such a child attains the age of 18, he may resume Indian citizenship. 2. By termination. When an Indian citizen voluntarily, consciously, knowingly and without duress, undue influence or compulsion acquires the citizenship of another country, his Indian citizenship automatically terminates. This provision, however, does not apply during a war in which India is engaged. 3. By deprivation. It is a compulsory termination of Indian citizenship by the central government if a. The citizen has obtained the citizenship by fraud. B. The citizen has shown disloyalty to the Constitution of India. C. The citizen has unlawfully traded or communicated with the enemy during a war. D. The citizen has, within 5 years after registration or naturalization, been imprisoned in any country for 2 years. And E. The citizen has been ordinarily resident out of India for 7 years continuously. Single citizenship. Though the Indian Constitution is federal and envisages a dual polity, center and states, it provides for only a single citizenship, that is, the Indian citizenship. The citizens in India owe allegiance only to the Union. There is no separate state citizenship. The other federal states like USA and Switzerland, on the other hand, adopted the system of double citizenship. In USA, each person is not only a citizen of USA but also of the particular state to which he belongs. Thus, he owes allegiance to both and enjoys dual sets of rights, one set conferred by the national government and another by the state government. This system creates the problem of discrimination, that is, a state may discriminate in favor of its citizens in matters like right to vote, right to hold public offices, right to practice professions, and so on. This problem is avoided in the system of single citizenship prevalent in India. In India, all citizens irrespective of the state in which they are born or reside enjoy the same political and civil rights of citizenship all over the country and no discrimination is made between them. However, this general rule of absence of discrimination is subject to some exceptions, viz. 1. The Parliament, under Article 16, can prescribe residence within a state or union territory as a condition for certain employments or appointments in that state or union territory, or local authority or other authority within that state or union territory. Accordingly, the Parliament enacted the Public Employment Requirement as to Residence Act 1957 and thereby authorized the Government of India to prescribe residential qualification only for appointment to non-gazetted posts in Andhra Pradesh, Himachal Pradesh, Manipur and Tripura. As this act expired in 1974, there is no such provision for any state except Andhra Pradesh and Telangana. 2. The Constitution, under Article 15, prohibits discrimination against any citizen on grounds of religion, race, caste, sex or place of birth and not on the ground of residence. This means that the state can provide special benefits or give preference to its residents in matters that do not come within the purview of the rights given by the Constitution to the Indian citizens. For example, a state may offer concession in fees for education to its residents. 3. The freedom of movement and residence, under Article 19, is subjected to the protection of interests of any scheduled tribe. In other words, the right of outsiders to enter, reside and settle in tribal areas is restricted. Of course, this is done to protect the distinctive culture, language, customs and manners of scheduled tribes and to safeguard their traditional vocation and property against exploitation. 4. Till 2019, the legislature of the erstwhile state of Jammu and Kashmir was empowered to a. Define the persons who are permanent residents of the state and b. Confer any special rights and privileges on such permanent residents as respects I. Employment under the state government, 2. Acquisition of immovable property in the state, 3. Settlement in the state, and 4. Right to scholarships and such other forms of aid provided by the government. The above provision was based on Article 35-A of the Constitution of India. This article was inserted in the Constitution by the Constitution, Application to Jammu and Kashmir, Order, 1954. This order was issued by the President under Article 370 of the Constitution, which had provided a special status to the erstwhile state of Jammu and Kashmir. In 2019, this special status was abolished by a new presidential order known as the Constitution, Application to Jammu and Kashmir, Order, 2019. This order superseded the earlier 1954 order. The Constitution of India like that of Canada, has introduced the system of single citizenship and provided uniform rights, except in few cases, for the people of India to promote the feeling of fraternity and unity among them and to build an integrated Indian nation. Despite this, India has been witnessing the communal riots, class conflicts, caste wars, linguistic clashes and ethnic disputes. Thus, the cherished goal of the founding fathers and the constitution makers to build an united and integrated Indian nation has not been fully realized. Overseas citizenship of India. In September 2000, the Government of India, Ministry of External Affairs, had set up a high-level committee on the Indian diaspora under the chairmanship of L.M. Singhvi. The mandate of the committee was to make a comprehensive study of the global Indian diaspora and to recommend measures for a constructive relationship with them. The committee submitted its report in January 2002. It recommended the amendment of the Citizenship Act, 1955, to provide for grant of dual citizenship to the persons of Indian origin, PIOs, belonging to certain specified countries. Accordingly, the Citizenship Amendment Act 2003 made provision for acquisition of overseas citizenship of India, OCI, by the PIOs of 16 specified countries other than Pakistan and Bangladesh. It also omitted all provisions recognizing or relating to the Commonwealth citizenship from the Principal Act. Later, the Citizenship Amendment Act 2005 expanded the scope of grant of OCI for PIOs of all countries except Pakistan and Bangladesh as long as their home countries all dual citizenship under their local laws. It must be noted here that the OCI is not actually a dual citizenships as the Indian Constitution forbids dual citizenship or dual nationality, Article 9. Again, the Citizenship Amendment Act 2015 has modified the provisions pertaining to the OCI in the Principal Act. It has introduced a new scheme called Overseas Citizen of India Cardholder by merging the PIO card scheme and the OCI card scheme. The PIO card scheme was introduced on 19 August 2002 and thereafter the OCI card scheme was introduced WEF 2 December 2005. Both the schemes were running in parallel even though the OCI card scheme had become more popular. This was causing unnecessary confusion in the minds of applicants. Keeping in view some problems being faced by applicants and to provide enhanced facilities to them, the Government of India decided to formulate one single scheme after merging the PIO and OCI schemes, containing positive attributes of both. Hence, for achieving this objective, the Citizenship Amendment Act 2015 was enacted. The PIO scheme was rescinded WEF 9 January 2015 and it was also notified that all existing PIO cardholders shall be deemed to be OCI cardholders WEF 9 January 2015. The Citizenship Amendment Act 2015 replaced the nomenclature of Overseas Citizen of India with that of Overseas Citizen of India cardholder and made the following provisions in the Principal Act. I. Registration of Overseas Citizen of India cardholder. 1. The central government may, on an application made in this behalf, register as an Overseas Citizen of India cardholder. A. Any person of full age and capacity, I, who is a citizen of another country, but was a citizen of India at the time of or at any time after the commencement of the Constitution, or 2. Who is a citizen of another country, but was eligible to become a citizen of India at the time of the commencement of the Constitution, or 3. Who is a citizen of another country, but belonged to a territory that became part of India after the 15th August 1947, or 4. Who is a child or a grandchild or a great-grandchild of such a citizen, or D. A person who is a minor child of a person mentioned in clause A, or C. A person who is a minor child and whose both parents are citizens of India, or one of the parents is a citizen of India, or D. Spouse of foreign origin of a citizen of India or spouse of foreign origin of an overseas citizen of India cardholder and whose marriage has been registered and subsisted for a continuous period of not less than 2 years immediately preceding the presentation of the application. No person who or either of whose parents or grandparents or great-grandparents is or had been a citizen of Pakistan, Bangladesh or such other country as the central government may specify, shall be eligible for registration as an overseas citizen of India cardholder. 2. The central government may specify the date from which the existing persons of Indian origin cardholders shall be deemed to be overseas citizens of India cardholders. 3. Notwithstanding anything contained in point 1, the central government may, if it is satisfied that special circumstances exist, after recording the circumstances in writing, register a person as an overseas citizen of India cardholder. 2. Conferment of rights on overseas citizen of India cardholder. 1. An overseas citizen of India cardholder shall be entitled to such rights as the central government may specify in this behalf. 2. An overseas citizen of India cardholder shall not be entitled to the following rights, which are conferred on a citizen of India. A. He shall not be entitled to the right to equality of opportunity in matters of public employment. B. He shall not be eligible for election as president. C. He shall not be eligible for election as vice president. D. He shall not be eligible for appointment as a judge of the Supreme Court. E. He shall not be eligible for appointment as a judge of the High Court. F. He shall not be entitled for registration as a voter. G. He shall not be eligible for being a member of the House of the People or of the Council of States. H. He shall not be eligible for being a member of the State Legislative Assembly or the State Legislative Council. I. He shall not be eligible for appointment to public services and posts in connection with affairs of the Union or of any state except for appointment in such services and posts as the central government may specify. 3. Renunciation of overseas citizen of India card. 1. If any overseas citizen of India cardholder makes in prescribed manner a declaration renouncing the card registering him as an overseas citizen of India cardholder, the declaration shall be registered by the central government, and upon such registration, that person shall cease to be an overseas citizen of India cardholder. 2. Where a person ceases to be an overseas citizen of India cardholder, the spouse of foreign origin of that person, who has obtained overseas citizen of India card and every minor child of that person registered as an overseas citizen of India cardholder shall thereupon cease to be an overseas citizen of India cardholder. 4. Cancellation of registration as overseas citizen of India card holder. The central government may cancel the registration of a person as an overseas citizen of India card holder if it is satisfied that a. The registration as an overseas citizen of India card holder was obtained by means of fraud, false representation or the concealment of any material fact, or b. The overseas citizen of India card holder has shown disaffection towards the Constitution of India, or c. The overseas citizen of India card holder has, during any war in which India may be engaged, unlawfully traded or communicated with an enemy, or d. The overseas citizen of India card holder has, within 5 years after registration, been sentenced to imprisonment for a term of not less than 2 years, or e. It is necessary so to do in the interests of the sovereignty and integrity of India, the security of India, friendly relations of India with any foreign country, or in the interests of the general public, or f. The marriage of an overseas citizen of India card holder, I, has been dissolved by a competent court of law or otherwise, or 2. Has not been dissolved but, during the subsistence of such marriage, he has solemnized marriage with any other person. Thank you so much for watching this video. If you want to buy this book, then link in the description, you can buy it from there. If this video helped you in any way, so please do like and share this video and hit the subscribe button. Laxmikanth Indian Polity Part 1. Chapter 7. Fundamental Rights. The fundamental rights are enshrined in Part 3 of the Constitution from Articles 12 to 35. In this regard, the framers of the Constitution derived inspiration from the Constitution of USA, that is, Bill of Rights. Part 3 of the Constitution is rightly described as the Magna Carta of India. It contains a very long and comprehensive list of justiciable fundamental rights. In fact, the fundamental rights in our Constitution are more elaborate than those found in the Constitution of any other country in the world, including the USA. The fundamental rights are guaranteed by the Constitution to all persons without any discrimination. They uphold the equality of all individuals, the dignity of the individual, the larger public interest and unity of the nation. The fundamental rights are meant for promoting the ideal of political democracy. They prevent the establishment of an authoritarian and despotic rule in the country and protect the liberties and freedoms of the people against the invasion by the state. They operate as limitations on the tyranny of the executive and arbitrary laws of the legislature. In short, they aim at establishing a government of laws and not of men. The fundamental rights are named so because they are guaranteed and protected by the Constitution, which is the fundamental law of the land. They are fundamental also in the sense that they are most essential for the all-round development, material, intellectual, moral and spiritual, of the individuals. Originally, the Constitution provided for 7 fundamental rights viz. 1. Right to equality, Articles 14 to 18. 2. Right to freedom, Articles 19 to 22. 3. Right against exploitation, Articles 23 to 24. 4. Right to freedom of religion, Articles 25 to 28. 5. Cultural and educational rights, Articles 29 to 30. 6. Right to property, Article 31. 7. Right to constitutional remedies, Article 32. However, the right to property was deleted from the list of fundamental rights by the 44th Amendment Act, 1978. It is made a legal right under Article 300A in Part 12 of the Constitution. So at present, there are only 6 fundamental rights. Features of fundamental rights. The fundamental rights guaranteed by the Constitution are characterized by the following. 1. Some of them are available only to the citizens, while others are available to all persons, whether citizens, foreigners, or legal persons like corporations or companies. 2. They are not absolute but qualified. The state can impose reasonable restrictions on them. However, whether such restrictions are reasonable or not is to be decided by the courts. Thus, they strike a balance between the rights of the individual and those of the society as a whole, between individual liberty and social control. 3. All of them are available against the arbitrary action of the state. However, some of them are also available against the action of private individuals. 4. Some of them are negative in character, that is, place limitations on the authority of the state, while others are positive in nature, conferring certain privileges on the persons. 5. They are justiciable, allowing persons to move the courts for their enforcement, if and when they are violated. 6. They are defended and guaranteed by the Supreme Court. Hence, the aggrieved person can directly go to the Supreme Court, not necessarily by way of appeal against the judgment of the high courts. 7. They are not sacrosanct or permanent. The Parliament can curtail or repeal them, but only by a Constitutional Amendment Act and not by an ordinary act. Moreover, this can be done without affecting the basic structure of the Constitution. The amenability of fundamental rights is explained in detail in Chapter 11. 8. They can be suspended during the operation of a national emergency except the rights guaranteed by Articles 20 and 21. Further, the 6 rights guaranteed by Article 19 can be suspended only when emergency is declared on the grounds of war or external aggression, i.e., external emergency, and not on the ground of armed rebellion, i.e., internal emergency. The suspension of fundamental rights during a national emergency is explained in detail in Chapter 16. 9. Their scope of operation is limited by Article 31A, saving of laws providing for acquisition of estates, etc., Article 31B, validation of certain acts and regulations included in the 9th schedule, and Article 31C, saving of laws giving effect to certain directive principles. 10. Their application to the members of armed forces, paramilitary forces, police forces, intelligence agencies and analogous services can be restricted or abrogated by the Parliament, Article 33. 11. Their application can be restricted while martial law is in force in any area. Martial law means military rule imposed under abnormal circumstances to restore order, Article 34. It is different from the imposition of national emergency. 12. Most of them are directly enforceable, self-executory, while a few of them can be enforced on the basis of a law made for giving effect to them. Such a law can be made only by the Parliament and not by state legislatures, so that uniformity throughout the country is maintained, Article 35. Definition of state. The term state has been used in different provisions concerning the fundamental rights. Hence, Article 12 has defined the term for the purposes of Part 3. According to it, the state includes the following. A. Government and Parliament of India, that is, executive and legislative organs of the Union Government. B. Government and legislature of states, that is, executive and legislative organs of state government. C. All local authorities, that is, municipalities, panchayats, district boards, improvement trusts, etc. D. All other authorities, that is, statutory or non-statutory authorities like LIC, ONGC, SAIL, etc. Thus, state has been defined in a wider sense so as to include all its agencies. It is the actions of these agencies that can be challenged in the courts as violating the fundamental rights. According to the Supreme Court, even a private body or an agency working as an instrument of the state falls within the meaning of the state under Article 12. Laws inconsistent with fundamental rights. Article 13 declares that all laws that are inconsistent with or in derogation of any of the fundamental rights shall be void. In other words, it expressively provides for the doctrine of judicial review. This power has been conferred on the Supreme Court, Article 32, and the High Courts, Article 226, that can declare a law unconstitutional and invalid on the ground of contravention of any of the fundamental rights. The term law in Article 13 has been given a wide connotation so as to include the following: a. Permanent laws enacted by the Parliament or the state legislatures. B. Temporary laws like ordinances issued by the President or the state governors. C. Statutory instruments in the nature of delegated legislation, executive legislation, like order, bylaw, rule, regulation or notification, and D. Non-legislative sources of law, that is, custom or usage having the force of law. Thus, not only a legislation but any of the above can be challenged in the courts as violating a fundamental right and hence can be declared as void. Further, Article 13 declares that a constitutional amendment is not a law and hence cannot be challenged. However, the Supreme Court held in the Keshwanand Bharti case, 1973, that a constitutional amendment can be challenged on the ground that it violates a fundamental right that forms a part of the basic structure of the Constitution and hence can be declared as void. Table 7.1 Fundamental Rights at a glance. Table 7.2 Fundamental Rights, FR, of Foreigners. Right to equality. 1. Equality before law and equal protection of laws. Article 14 says that the state shall not deny to any person equality before the law or the equal protection of the laws within the territory of India. This provision confers rights on all persons, whether citizens or foreigners. Moreover, the word person includes legal persons, viz. Statutory corporations, companies, registered societies or any other type of legal person. The concept of equality before law is of British origin while the concept of equal protection of laws has been taken from the American Constitution. The first concept connotes a. The absence of any special privileges in favor of any person. B. The equal subjection of all persons to the ordinary law of the land administered by ordinary law courts. And C. No person, whether rich or poor, high or low, official or non-official, is above the law. The second concept, on the other hand, connotes a. The equality of treatment under equal circumstances, both in the privileges conferred and liabilities imposed by the laws. B. The similar application of the same laws to all persons who are similarly situated, and C. The like should be treated alike without any discrimination. Thus, the former is a negative concept while the latter is a positive concept. However, both of them aim at establishing equality of legal status, opportunity and justice. The Supreme Court held that where equals and unequals are treated differently, Article 14 does not apply. While Article 14 forbids class legislation, it permits reasonable classification of persons, objects and transactions by the law. But the classification should not be arbitrary, artificial or evasive. Rather, it should be based on an intelligible differential and substantial distinction. Rule of law. The concept of equality before law is an element of the concept of rule of law propounded by A.V. Dicey, the British jurist. His concept has the following three elements or aspects. I. Absence of arbitrary power, that is, no man can be punished except for a breach of law. 2. Equality before the law, that is, equal subjection of all citizens, rich or poor, high or low, official or non-official, to the ordinary law of the land administered by the ordinary law courts. 3. The primacy of the rights of the individual, that is, the Constitution is the result of the rights of the individual as defined and enforced by the courts of law rather than the Constitution being the source of the individual rights. The first and the second elements are applicable to the Indian system and not the third one. In the Indian system, the Constitution is the source of the individual rights. The Supreme Court held that the rule of law as embodied in Article 14 is a basic feature of the Constitution. Hence, it cannot be destroyed even by an amendment. Exceptions to equality. The rule of equality before law is not absolute and there are constitutional and other exceptions to it. These are mentioned below. 1. The President of India and the Governor of States enjoy the following immunities. Article 361. I. The President or the Governor is not answerable to any court the exercise and performance of the powers and duties of his office. 2. No criminal proceedings shall be instituted or continued against the President or the Governor in any court during his term office. 3. No process for the arrest or imprisonment of the President or the Governor shall be issued from any court during his term of office. 4. No civil proceedings against the President or the Governor shall be instituted during his term of office in any court in respect of any act done by him in his personal capacity, whether before or after he entered upon his office, until the expiration of 2 months next after notice has been delivered to him. 2. No person shall be liable to any civil or criminal proceedings in any court in respect of the publication in a newspaper, or by radio or television, of a substantially true report of any proceedings of either House of Parliament or either House of the Legislature of a state. Article 361-A. 3. No member of Parliament shall be liable to any proceedings in any court in respect of anything said or any vote given by him in Parliament or any committee thereof. Article 105. 4. No member of the legislature of a state shall be liable to any proceedings in any court in respect of anything said or any vote given by him in the legislature or any committee thereof. Article 194. 5. Article 31C is an exception to Article 14. It provides that the laws made by the state for implementing the directive principles contained in Clause B or Clause C of Article 39 cannot be challenged on the ground that they are violative of Article 14. The Supreme Court held that where Article 31C comes in, Article 14 goes out. 6. The foreign sovereigns, rulers, ambassadors and diplomats enjoy immunity from criminal and civil proceedings. 7. The UNO and its agencies enjoy the diplomatic immunity. 2. Prohibition of discrimination on certain grounds. Article 15 provides that the state shall not discriminate against any citizen on grounds only of religion, race, caste, sex or place of birth. The two crucial words in this provision are discrimination and only. The word discrimination means to make an adverse distinction with regard to or to distinguish unfavorably from others. The use of the word only connotes that discrimination on other grounds is not prohibited. The second provision of Article 15 says that no citizen shall be subjected to any disability, liability, restriction or condition on grounds only of religion, race, caste, sex, or place of birth with regard to a. access to shops, public restaurants, hotels and places of public entertainment or b. the use of wells, tanks, bathing ghats, road and places of public resort maintained wholly or partly by state funds or dedicated to the use of general public. This provision prohibits discrimination both by the state and private individuals, while the former provision prohibits discrimination only by the state. There are 4 exceptions to this general rule of non-discrimination. The state is permitted to make any special provision for women and children. For example, reservation of seats for women in local bodies or provision of free education for children. B. The state is permitted to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes and scheduled tribes. For example, reservation of seats or fee concessions in public educational institutions. C. The state is empowered to make any special provision for the advancement of any socially and educationally backward classes of citizens or for the scheduled castes or the scheduled tribes regarding their admission to educational institutions including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. D. The state is empowered to make any special provision for the advancement of any economically weaker sections of citizens. Further, the state is allowed to make a provision for the reservation of up to 10% of seats for such sections in admission to educational institutions including private educational institutions, whether aided or unaided by the state, except the minority educational institutions. This reservation of up to 10% would be in addition to the existing reservations. For this purpose, the economically weaker sections would be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Reservation for OBCs in educational institutions. The above exception, C, was added by the 93rd Amendment Act of 2005. In order to give effect to this provision, the Centre enacted the Central Educational Institutions Reservation in Admission Act 2006, providing a quota of 27% for candidates belonging to the other backward classes, OBCs, in all central higher educational institutions including the Indian Institutes of Technology, IITs, and the Indian Institutes of Management, IIMs. In April 2008, the Supreme Court upheld the validity of both the Amendment Act and the OBC Quota Act. But the court directed the central government to exclude the creamy layer, advanced sections, among the OBCs while implementing the law. The children of the following different categories of people belong to creamy layer among OBCs and thus will not get the quota benefit. 1. Persons holding constitutional posts like President, Vice President, judges of SC and HCs, chairmen and members of UPSC and SPSCs, CEC, CAG and so on. 2. Group A Class I and Group B Class II officers of the All India, Central and State Services and employees holding equivalent posts in PSUs, banks, insurance organizations, universities etc. and also in private employment. 3. Persons who are in the rank of colonel and above in the Army and equivalent posts in the Navy, the Air Force and the paramilitary forces. 4. Professionals like doctors, lawyers, engineers, artists, authors, consultants and so on. 5. Persons engaged in trade, business and industry. 6. People holding agricultural land above a certain limit and vacant land or buildings in urban areas. 7. Persons having gross annual income of more than 8 lakh rupees or possessing wealth above the exemption limit. In 1993, when the creamy layer ceiling was introduced, it was 1 lakh rupees. It was subsequently revised to 2.5 lakh rupees in 2004, 4.5 lakh rupees in 2008, 6 lakh rupees in 2013 and 8 lakh rupees in 2017. Reservation for EWSs in educational institutions. The above exception, D, was added by the 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order in 2019 providing 10% reservation to the economically weaker sections, EWSs, in admission to educational institutions. The benefit of this reservation can be availed by the persons belonging to EWSs who are not covered under any of the existing schemes of reservations for SCs, STs and OBCs. The eligibility criteria laid down in this regard is as follows. 1. Persons whose family has gross annual income below 8 lakh rupees are to be identified as EWSs for the benefit of reservation. The income would include income from all sources, i.e., salary, agriculture, business, profession, etc., and it would be income for the financial year prior to the year of application. 2. Persons whose family owns or possesses any one of the following assets are to be excluded from being identified as EWSs, irrespective of the family income. A. 5 acres of agricultural land and above. B. Residential flat of 1000 square feet and above. C. Residential plot of 100 SQ yards and above in notified municipalities. D. Residential plot of 200 SQ yards and above in areas other than the notified municipalities. 3. The property held by a family in different locations or different places, cities, would be clubbed while applying the land or property holding test to determine EWS status. 4. Family for this purpose would include the person who seeks benefit of reservation, his/her parents and siblings below the age of 18 years, as also his/her spouse and children below the age of 18 years. 3. Equality of opportunity in public employment. Article 16 provides for equality of opportunity for all citizens in matters of employment or appointment to any office under the state. No citizen can be discriminated against or be ineligible for any employment or office under the state on grounds of only religion, race, caste, sex, descent, place of birth or residence. There are 4 exceptions to this general rule of equality of opportunity in public employment. A. Parliament can prescribe residence as a condition for certain employment or appointment in a state or union territory or local authority or other authority. As the Public Employment Requirement as to Residence Act of 1957 expired in 1974, there is no such provision for any state except Andhra Pradesh and Telangana. B. The state can provide for reservation of appointments or posts in favor of any backward class that is not adequately represented in the state services. C. A law can provide that the incumbent of an office related to religious or denominational institution or a member of its governing body should belong to the particular religion or denomination. D. The state is permitted to make a provision for the reservation of up to 10% of appointments or posts in favor of any economically weaker sections of citizens. This reservation of up to 10% would be in addition to the existing reservation. For this purpose, the economically weaker sections would be notified by the state from time to time on the basis of family income and other indicators of economic disadvantage. Mandal Commission and Aftermath. In 1979, the Morarji Desai government appointed the second Backward Classes Commission under the chairmanship of B.P. Mandal, a member of parliament, in terms of Article 340 of the Constitution to investigate the conditions of the socially and educationally backward classes and suggest measures for their advancement. The Commission submitted its report in 1980 and identified as many as 3,743 castes as socially and educationally backward classes. They constitute nearly 52% component of the population, excluding the scheduled castes, SCs, and the Scheduled Tribes, STs. The Commission recommended for reservation of 27% government jobs for the other backward classes, OBCs, so that the total reservation for all, SCs, STs and OBCs, amounts to 50%. It was after 10 years in 1990 that the VP Singh government declared reservation of 27% government jobs for the OBCs. Again in 1991, the Narasimha Rao government introduced two changes: a. preference to the poorer sections among the OBCs in the 27% quota, that is adoption of the economic criteria in granting reservation, and b. reservation of another 10% of jobs for poorer, economically backward sections of higher castes who are not covered by any existing schemes of reservation. In the famous Mandal case, 1992, the scope and extent of Article 16(4), which provides for reservation of jobs in favor of backward classes, has been examined thoroughly by the Supreme Court. Though the court has rejected the additional reservation of 10% for poorer sections of higher castes, it upheld the constitutional validity of 27% reservation for the OBCs with certain conditions, viz. A. The advanced sections among the OBCs, the creamy layer, should be excluded from the list of beneficiaries of reservation. B. No reservation in promotions. Reservation should be confined to initial appointments only. Any existing reservation in promotions can continue for 5 years only, that is up to 1997. C. The total reserved quota should not exceed 50% except in some extraordinary situations. This rule should be applied every year. D. The carry-forward rule in case of unfilled, backlog, vacancies is valid. But it should not violate 50% rule. E. A permanent statutory body should be established to examine complaints of over-inclusion and under-inclusion in the list of OBCs. With regard to the above rulings of the Supreme Court, the government has taken the following actions. A. Ram Nandan Committee was appointed to identify the creamy layer among the OBCs. It submitted its report in 1993, which was accepted. B. National Commission for Backward Classes was established in 1993 by an Act of Parliament. Its mandate was to examine the complaints of under-inclusion, over-inclusion or non-inclusion of any class of citizens in the list of backward classes for the purpose of job reservation. Later, the 102nd Amendment Act of 2018 conferred a constitutional status on the Commission and also enlarged its functions. For this purpose, the amendment inserted a new Article 338B in the Constitution. C. In order to nullify the ruling with regard to reservation in promotions, the 77th Amendment Act was enacted in 1995. It added a new provision in Article 16 that empowers the state to provide for reservation in promotions of any services under the state in favor of the SCs and STs that are not adequately represented in the state services. Again, the 85th Amendment Act of 2001 provides for consequential seniority in the case of promotion by virtue of rule of reservation for the government servants belonging to the SCs and STs with retrospective effect from June 1995. D. The ruling with regard to backlog vacancies was nullified by the 81st Amendment Act of 2000. It added another new provision in Article 16 that empowers the state to consider the unfilled reserved vacancies of a year as a separate class of vacancies to be filled up in any succeeding year or years. Such class of vacancies are not to be combined with the vacancies of the year in which they are being filled up to determine the ceiling of 50% reservation on total number of vacancies of that year. In brief, it ends the 50% ceiling on reservation in backlog vacancies. E. The 76th Amendment Act of 1994 has placed the Tamil Nadu Reservations Act of 1994 in the 9th schedule to protect it from judicial review, as it provided for 69% of reservation, far exceeding the 50% ceiling. Reservation for EWSs in public employment. The above exception, D, was added by the 103rd Amendment Act of 2019. In order to give effect to this provision, the central government issued an order in 2019 providing 10% reservation to the economically weaker sections, EWSs, in civil posts and services in the Government of India. The benefit of this reservation can be availed by the persons belonging to EWSs who are not covered under any of the existing schemes of reservation for SCs, STs and OBCs. The eligibility criteria laid down in this regard has already been explained under Article 15. Further, the scientific and technical posts which satisfy all the following conditions can be exempted from the purview of this reservation. I. The posts should be in grades above the lower grade in Group A of the service concerned. 2. They should be classified as scientific or technical in terms of Cabinet Secretariat Order, 1961, according to which scientific and technical posts for which qualifications in the natural sciences or exact sciences or applied sciences or in technology are prescribed, and the incumbents of which have to use that knowledge in the discharge of their duties. 3. The posts should be for conducting research or for organizing, guiding and directing research. 4. Abolition of untouchability. Article 17 abolishes untouchability and forbids its practice in any form. The enforcement of any disability arising out of untouchability shall be an offence punishable in accordance with law. In 1976, the Untouchability Offences Act 1955 has been comprehensively amended and renamed as the Protection of Civil Rights Act 1955 to enlarge the scope and make penal provisions more stringent. The Act defines civil right as any right accruing to a person by reason of the abolition of untouchability by Article 17 of the Constitution. The term untouchability has not been defined either in the Constitution or in the Act. However, the Mysore High Court held that the subject matter of Article 17 is not untouchability in its literal or grammatical sense but the practice as it had developed historically in the country. It refers to the social disabilities imposed on certain classes of persons by reason of their birth in certain castes. Hence, it does not cover social boycott of a few individuals or their exclusion from religious services, etc. The Supreme Court held that the right under Article 17 is available against private individuals and it is the constitutional obligation of the state to take necessary action to ensure that this right is not violated. 5. Abolition of titles. Article 18 abolishes titles and makes 4 provisions in that regard. A. It prohibits the state from conferring any title, except a military or academic distinction, on anybody, whether a citizen or a foreigner. B. It prohibits a citizen of India from accepting any title from any foreign state. C. A foreigner holding any office of profit or trust under the state cannot accept any title from any foreign state without the consent of the President. D. No citizen or foreigner holding any office of profit or trust under the state is to accept any present, emolument or office from or under any foreign state without the consent of the President. From the above, it is clear that the hereditary titles of nobility like Maharaja, Raj Bahadur, Rai Bahadur, Rai Sahib, Dewan Bahadur, etc., which were conferred by colonial states are banned by Article 18 as these are against the principle of equal status of all. In 1996, The Supreme Court upheld the constitutional validity of the national awards Bharat Ratna, Padma Vibhushan, Padma Bhushan and Padma Shri. It ruled that these awards do not amount to titles within the meaning of Article 18 that prohibits only hereditary titles of nobility. Therefore, they are not violative of Article 18 as the theory of equality does not mandate that merit should not be recognized. However, it also ruled that they should not be used as suffixes or prefixes to the names of awardees. Otherwise, they should forfeit the awards. These national awards were instituted in 1954. The Janata Party government headed by Morarji Desai discontinued them in 1977. But they were again revived in 1980 by the Indira Gandhi government. Thank you so much for watching this video. If you want to buy this book, then link in the description, you can buy it from there. If this video helped you in any way, so please do like and share this video and hit the subscribe button. Laxmikanth, Indian Polity. Chapter 7. Fundamental Rights. Part 2. Right to Freedom. 1. Protection of 6 rights. Article 19 guarantees to all citizens the 6 rights. These are I. Right to freedom of speech and expression. 2. Right to assemble peaceably and without arms. 3. Right to form associations or unions or cooperative societies. 10a. 4. Right to move freely throughout the territory of India. V. Right to reside and settle in any part of the territory of India. 6. Right to practice any profession or to carry on any occupation, trade or business. Originally, Article 19 contained 7 rights. But the right to acquire, hold and dispose of property was deleted by the 44th Amendment Act of 1978. These 6 rights are protected against only state action and not private individuals. Moreover, these rights are available only to the citizens and to shareholders of a company but not to foreigners or legal persons like companies or corporations, etc. The state can impose reasonable restrictions on the enjoyment of these 6 rights only on the grounds mentioned in the Article 19 itself and not on any other grounds. Freedom of speech and expression. It implies that every citizen has the right to express his views, opinions, belief and convictions freely by word of mouth, writing, printing, picturing or in any other manner. The Supreme Court held that the freedom of speech and expression includes the following. A. Right to propagate one's views as well as views of others. B. Freedom of the press. C. Freedom of commercial advertisements. D. Right against tapping of telephonic conversation. E. Right to telecast, that is, government has no monopoly on electronic media. F. Right against band called by a political party or organization. G. Right to know about government activities. H. Freedom of silence. I. Right against imposition of pre-censorship on a newspaper. J. Right to demonstration or picketing but not right to strike. The state can impose reasonable restrictions on the exercise of the freedom of speech and expression on the grounds of sovereignty and integrity of India, security of the state, friendly relations with foreign states, public order, decency or morality, contempt of court, defamation, and incitement to an offense. Freedom of assembly. Every citizen has the right to assemble peaceably and without arms. It includes the right to hold public meetings, demonstrations, and take out processions. This freedom can be exercised only on public land, and the assembly must be peaceful and unarmed. This provision does not protect violent, disorderly, riotous assemblies, or one that causes breach of public peace or one that involves arms. This right does not include the right to strike. The state can impose reasonable restrictions on the exercise of right of assembly on two grounds, namely, sovereignty and integrity of India and public order, including the maintenance of traffic in the area concerned. Under Section 144 of Criminal Procedure Code, 1973, a magistrate can restrain an assembly, meeting or procession if there is a risk of obstruction, annoyance or danger to human life, health or safety, or a disturbance of the public tranquility, or a riot or any affray. Under Section 141 of the Indian Penal Code, as assembly of 5 or more persons becomes unlawful if the object is a. To resist the execution of any law or legal process, b. To forcibly occupy the property of some person, c. To commit any mischief or criminal trespass, d. To force some person to do an illegal act, and e. To threaten the government or its officials on exercising lawful powers. Freedom of association. All citizens have the right to form associations or unions or cooperative societies. It includes the right to form political parties, companies, partnership firms, societies, clubs, organizations, trade unions, or any body of persons. It not only includes the right to start an association or union but also to continue with the association or union as such. Further, it covers the negative right of not to form or join an association or union. Reasonable restrictions can be imposed on the exercise of this right by the state on the grounds of sovereignty and integrity of India, public order and morality. Subject to these restrictions, the citizens have complete liberty to form associations or unions for pursuing lawful objectives and purposes. However, the right to obtain recognition of the association is not a fundamental right. The Supreme Court held that the trade unions have no guaranteed right to effective bargaining or right to strike or right to declare a lockout. The right to strike can be controlled by an appropriate industrial law. Freedom of movement. This freedom entitles every citizen to move freely throughout the territory of the country. He can move freely from one state to another or from one place to another within a state. This right underlines the idea that India is one unit so far as the citizens are concerned. Thus, the purpose is to promote national feeling and not parochialism. The grounds of imposing reasonable restrictions on this freedom are two, namely, the interests of general public and the protection of interests of any scheduled tribe. The entry of outsiders in tribal areas is restricted to protect the distinctive culture, language, customs and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. The Supreme Court held that the freedom of movement of prostitutes can be restricted on the ground of public health and in the interest of public morals. The Bombay High Court validated the restrictions on the movement of persons affected by AIDS. The freedom of movement has two dimensions, viz. Internal, right to move inside the country, and external, right to move out of the country and right to come back to the country. Article 19 protects only the first dimension. The second dimension is dealt by Article 21, right to life and personal liberty. Freedom of residence. Every citizen has the right to reside and settle in any part of the territory of the country. This right has two parts. A. The right to reside in any part of the country, which means to stay at any place temporarily, and b. The right to settle in any part of the country, which means to set up a home or domicile at any place permanently. This right is intended to remove internal barriers within the country or between any of its parts. This promotes nationalism and avoids narrow-mindedness. The state can impose reasonable restrictions on the exercise of this right on two grounds, namely, the interest of general public and the protection of interests of any scheduled tribes. The right of outsiders to reside and settle in tribal areas is restricted to protect the distinctive culture, language, customs and manners of scheduled tribes and to safeguard their traditional vocation and properties against exploitation. In many parts of the country, the tribunals have been permitted to regulate their property rights in accordance with their customary rules and laws. The Supreme Court held that certain areas can be banned for certain kinds of persons like prostitutes and habitual offenders. From the above, it is clear that the right to residence and the right to movement are overlapping to some extent. Both are complementary to each other. Freedom of profession, etc. All citizens are given the right to practice any profession or to carry on any occupation, trade or business. This right is very wide as it covers all the means of earning one's livelihood. The state can impose reasonable restrictions on the exercise of this right in the interest of the general public. Further, the state is empowered to a. prescribe professional or technical qualifications necessary for practicing any profession or carrying on any occupation, trade or business, and b. carry on by itself any trade, business, industry or service whether to the exclusion, complete or partial, of citizens or otherwise. Thus, no objection can be made when the state carries on a trade, business, industry or service either as a monopoly, complete or partial, to the exclusion of citizens, all or some only, or in competition with any citizen. The state is not required to justify its monopoly. This right does not include the right to carry on a profession or business or trade or occupation that is immoral, trafficking in women or children, or dangerous, harmful drugs or explosives, etc. The state can absolutely prohibit these or regulate them through licensing. 2. Protection in respect of conviction for offences. Article 20 grants protection against arbitrary and excessive punishment to an accused person, whether citizen or foreigner or legal person like a company or a corporation. It contains 3 provisions in that direction. A. No ex post facto law. No person shall be I. convicted of any offence except for violation of a law in force at the time of the commission of the act, nor 2. subjected to a penalty greater than that prescribed by the law in force at the time of the commission of the act. B. No double jeopardy. No person shall be prosecuted and punished for the same offence more than once. C. No self-incrimination. No person accused of any offence shall be compelled to be a witness against himself. An ex post facto law is one that imposes penalties retrospectively, that is, upon acts already done or which increases the penalties for such acts. The enactment of such a law is prohibited by the first provision of Article 20. However, this limitation is imposed only on criminal laws and not on civil laws or tax laws. In other words, a civil liability or a tax can be imposed retrospectively. Further, this provision prohibits only conviction or sentence under an ex post facto criminal law and not the trial thereof. Finally, the protection, immunity, under this provision cannot be claimed in case of preventive detention or demanding security from a person. The protection against double jeopardy is available only in proceedings before a court of law or a judicial tribunal. In other words, it is not available in proceedings before departmental or administrative authorities as they are not of judicial nature. The protection against self-incrimination extends to both oral evidence and documentary evidence. However, it does not extend to I. compulsory production of material objects, 2. Compulsion to give thumb impression, specimen signature, blood specimens, and 3. Compulsory exhibition of the body. Further, it extends only to criminal proceedings and not to civil proceedings or proceedings which are not of criminal nature. 3. Protection of life and personal liberty. Article 21 declares that no person shall be deprived of his life or personal liberty except according to procedure established by law. This right is available to both citizens and non-citizens. In the famous Gopalan case 11, 1950, the Supreme Court has taken a narrow interpretation of the Article 21. It held that the protection under Article 21 is available only against arbitrary executive action and not from arbitrary legislative action. This means that the state can deprive the right to life and personal liberty of a person based on a law. This is because of the expression procedure established by law in Article 21, which is different from the expression due process of law contained in the American Constitution. Hence, the validity of a law that has prescribed a procedure cannot be questioned on the ground that the law is unreasonable, unfair or unjust. Secondly, the Supreme Court held that the personal liberty means only liberty relating to the person or body of the individual. But, in Menka case, 1978, the Supreme Court overruled its judgment in the Gopalan case by taking a wider interpretation of the Article 21. Therefore, it ruled that the right to life and personal liberty of a person can be deprived by a law provided the procedure prescribed by that law is reasonable, fair and just. In other words, it has introduced the American expression due process of law. In effect, the protection under Article 21 should be available not only against arbitrary executive action but also against arbitrary legislative action. Further, the court held that the right to life as embodied in Article 21 is not merely confined to animal existence or survival but it includes within its ambit the right to live with human dignity and all those aspects of life which go to make a man's life meaningful, complete and worth living. It also ruled that the expression personal liberty in Article 21 is of the widest amplitude and it covers a variety of rights that go to constitute the personal liberties of a man. The Supreme Court has reaffirmed its judgment in the Menka case in the subsequent cases. It has declared the following rights as part of Article 21. 1. Right to live with human dignity. 2. Right to decent environment including pollution-free water and air and protection against hazardous industries. 3. Right to livelihood. 4. Right to privacy. 5. Right to shelter. 6. Right to health. 7. Right to free education up to 14 years of age. 8. Right to free legal aid. 9. Right against solitary confinement. 10. Right to speedy trial. 11. Right against handcuffing. 12. Right against inhuman treatment. 13. Right against delayed execution. 14. Right to travel abroad. 15. Right against bonded labor. 16. Right against custodial harassment. 17. Right to emergency medical aid. 18. Right to timely medical treatment in government hospital. 19. Right not to be driven out of a state. 20. Right to fair trial. 21. Right of prisoner to have necessities of life. 22. Right of women to be treated with decency and dignity. 23. Right against public hanging. 24. Right to road in hilly areas. 25. Right to information. 26. Right to reputation. 27. Right of appeal from a judgment of conviction. 28. Right to family pension. 29. Right to social and economic justice and empowerment. 30. Right against bar fetters. 31. Right to appropriate life insurance policy. 32. Right to sleep. 33. Right to freedom from noise pollution. 34. Right to sustainable development. 35. Right to opportunity. Thank you so much for watching this video. If you want to buy this book, then link in the description, you can buy it from there. If this video helped you in any way, so please do like and share this video and hit the subscribe button. Laxmikanth, Indian Polity. Chapter 7. Fundamental Rights. Part 3. 4. Right to education. Article 21 AM declares that the state shall provide free and compulsory education to all children of the age of 6 to 14 years in such a manner as the state may determine. Thus, this provision makes only elementary education a fundamental right and not higher or professional education. This provision was added by the 86th Constitutional Amendment Act of 2002. This amendment is a major milestone in the country's aim to achieve education for all. The government described this step as the dawn of the second revolution in the chapter of citizens' rights. Even before this amendment, the Constitution contained a provision for free and compulsory education for children under Article 45 in Part 4. However, being a directive principle, it was not enforceable by the courts. Now, there is scope for judicial intervention in this regard. This amendment changed the subject matter of Article 45 in Directive Principles. It now reads, "The state shall endeavour to provide early childhood care and education for all children until they complete the age of 6 years." It also added a new fundamental duty under Article 51A that reads, "It shall be the duty of every citizen of India to provide opportunities for education to his child or ward between the age of 6 and 14 years." In 1993 itself, the Supreme Court recognized a fundamental right to primary education in the right to life under Article 21. It held that every child or citizen of this country has a right to free education until he completes the age of 14 years. Thereafter, his right to education is subject to the limits of economic capacity and development of the state. In this judgment, the court overruled its earlier judgment, 1992, which declared that there was a fundamental right to education up to any level including professional education like medicine and engineering. In pursuance of Article 21, the Parliament enacted the Right of Children to Free and Compulsory Education, RTE, Act, 2009. This act seeks to provide that every child has a right to be provided full-time elementary education of satisfactory and equitable quality in a formal school which satisfies certain essential norms and standards. This legislation is anchored in the belief that the values of equality, social justice and democracy and the creation of a just and humane society can be achieved only through provision of inclusive elementary education to all. 5. Protection against arrest and detention. Article 22 grants protection to persons who are arrested or detained. Detention is of two types, namely, punitive and preventive. Punitive detention is to punish a person for an offense committed by him after trial and conviction in a court. Preventive detention, on the other hand, means detention of a person without trial and conviction by a court. Its purpose is not to punish a person for a past offense, but to prevent him from committing an offense in the near future. Thus, preventive detention is only a precautionary measure and based on suspicion. The Article 22 has two parts. The first part deals with the cases of ordinary law, and the second part deals with the cases of preventive detention law. The first part of Article 22 confers the following rights on a person who is arrested or detained under an ordinary law. I. Right to be informed of the grounds of arrest. 2. Right to consult and be defended by a legal practitioner. 3. Right to be produced before a magistrate within 24 hours including the journey time. 4. Right to be released after 24 hours unless the magistrate authorizes further detention. These safeguards are not available to an enemy alien or a person arrested or detained under a preventive detention law. The Supreme Court also ruled that the arrest and detention in the first part of Article 22 do not cover arrest under the orders of a court, civil arrest, arrest on failure to pay the income tax, and deportation of an alien. They apply only to an act of a criminal or quasi-criminal nature or some activity prejudicial to public interest. B. The second part of Article 22 grants protection to persons who are arrested or detained under a preventive detention law. This protection is available to both citizens as well as aliens and includes the following. I. The detention of a person cannot exceed 3 months unless an advisory board reports sufficient cause for extended detention. The board is to consist of judges of a high court. 2. The grounds of detention should be communicated to the detenu. However, the facts considered to be against the public interest need not be disclosed. 3. The detenu should be afforded an opportunity to make a representation against the detention order. Article 22 also authorizes the Parliament to prescribe the circumstances and the classes of cases in which a person can be detained for more than 3 months under a preventive detention law without obtaining the opinion of an advisory board. B. The maximum period for which a person can be detained in any classes of cases under a preventive detention law, and C. The procedure to be followed by an advisory board in an inquiry. The 44th Amendment Act of 1978 has reduced the period of detention without obtaining the opinion of an advisory board from 3 to 2 months. However, this provision has not yet been brought into force, hence, the original period of 3 months still continues. The Constitution has divided the legislative power with regard to preventive detention between the Parliament and the state legislatures. The Parliament has exclusive authority to make a law of preventive detention for reasons connected with defense, foreign affairs and the security of India. Both the Parliament as well as the state legislatures can concurrently make a law of preventive detention for reasons connected with the security of a state, the maintenance of public order and the maintenance of supplies and services essential to the community. The preventive detention laws made by the Parliament are A. Preventive Detention Act, 1950. Expired in 1969. B. Maintenance of Internal Security Act, MISA, 1971. Repealed in 1978. C. Conservation of Foreign Exchange and Prevention of Smuggling Activities Act, COFEPOSA, 1974. D. National Security Act, NASA, 1980. E. Prevention of Black Marketing and Maintenance of Supplies of Essential Commodities Act, PBMSEK, 1980. F. Terrorist and Disruptive Activities Prevention Act, TADA, 1985. Repealed in 1995. G. Prevention of Illicit Traffic in Narcotic Drugs and Psychotropic Substances Act, PITNT-SA, 1988. H. Prevention of Terrorism Act, POTA, 2002. Repealed in 2004. I. Unlawful Activities Prevention Act, UAPA, 1967, as amended in 2004, 2008, 2012 and 2019. It is unfortunate to know that no democratic country in the world has made preventive detention as an integral part of the Constitution as has been done in India. It is unknown in USA. It was resorted to in Britain only during First and Second World War time. In India, preventive detention existed even during the British rule. For example, the Bengal State Prisoners Regulation of 1818 and the Defence of India Act of 1939 provided for preventive detention. Right against exploitation. 1. Prohibition of traffic in human beings and forced labour. Article 23 prohibits traffic in human beings, begar, forced labour, and other similar forms of forced labour. Any contravention of this provision shall be an offence punishable in accordance with law. This right is available to both citizens and non-citizens. It protects the individual not only against the state but also against private persons. The expression traffic in human beings include a. Selling and buying of men, women and children like goods. b. Immoral traffic in women and children, including prostitution. c. Devdasis, and d. Slavery. To punish these acts, the Parliament has made the Immoral Traffic Prevention Act 1956. The term begar means compulsory work without remuneration. It was a peculiar Indian system under which the local zamindars sometimes used to force their tenants to render services without any payment. In addition to begar, the Article 23 prohibits other similar forms of forced labor like bonded labor. The term forced labor means compelling a person to work against his will. The word force includes not only physical or legal force, but also force arising from the compulsion of economic circumstances, that is, working for less than the minimum wage. In this regard, the Bonded Labor System Abolition Act 1976, the Minimum Wages Act 1948, the Contract Labor Act 1970 and the Equal Remuneration Act 1976 were made. Article 23 also provides for an exception to this provision. It permits the state to impose compulsory service for public purposes as for example, military service or social service, for which it is not bound to pay. However, in imposing such service, the state is not permitted to make any discrimination on grounds only of religion, race, caste or class. 2. Prohibition of employment of children in factories, etc. Article 24 prohibits the employment of children below the age of 14 years in any factory, mine or other hazardous activities like construction work or railway. But it does not prohibit their employment in any harmless or innocent work. The Child Labour Prohibition and Regulation Act 1986 is the most important law in this direction. In addition, the Employment of Children Act 1938, the Factories Act 1948, the Mines Act 1952, the Merchant Shipping Act 1958, the Plantation Labour Act 1951, the Motor Transport Workers Act 1951, Apprentices Act 1961, the Bidi and Cigar Workers Act 1966, and other similar acts prohibit the employment of children below certain age. In 1996, the Supreme Court directed the establishment of Child Labour Rehabilitation Welfare Fund, in which the offending employer should deposit a fine of 20,000 rupees for each child employed by him. It also issued directions for the improvement of education, health and nutrition of children. The Commissions for Protection of Child Rights Act 2005 was enacted to provide for the establishment of a National Commission and State Commissions for Protection of Child Rights and Children's Courts for providing speedy trial of offences against children or of violation of child rights. In 2006, the government banned the employment of children as domestic servants or workers in business establishments like hotels, dhabas, restaurants, shops, factories, resorts, spas, tea shops and so on. It warned that anyone employing children below 14 years of age would be liable for prosecution and penal action. The Child Labour, Prohibition and Regulation Amendment Act 2016 amended the Child Labour, Prohibition and Regulation Act 1986. It has renamed the Principal Act as the Child and Adolescent Labour, Prohibition and Regulation Act 1986. Right to freedom of religion. 1. Freedom of conscience and free profession, practice and propagation of religion. Article 25 says that all persons are equally entitled to freedom of conscience and the right to freely profess, practice and propagate religion. The implications of these are: A. Freedom of conscience, inner freedom of an individual to mold his relation with God or creatures in whatever way he desires. B. Right to profess, declaration of one's religious beliefs and faith openly and freely. C. Right to practice, performance of religious worship, rituals, ceremonies and exhibition of beliefs and ideas. D. Right to propagate, transmission and dissemination of one's religious beliefs to others or exposition of the tenets of one's religion. But it does not include a right to convert another person to one's own religion. Forcible conversions impinge on the freedom of conscience guaranteed to all the persons alike. From the above, it is clear that Article 25 covers not only religious beliefs, doctrines, but also religious practices, rituals. Moreover, these rights are available to all persons, citizens as well as non-citizens. However, these rights are subject to public order, morality, health and other provisions relating to fundamental rights. Further, the state is permitted to A. Regulate or restrict any economic, financial, political or other secular activity associated with religious practice and B. Provide for social welfare and reform or throw open Hindu religious institutions of a public character to all classes and sections of Hindus. Article 25 also contains two explanations. 1. Wearing and carrying of kirpans is to be included in the profession of the Sikh religion, and 2. The Hindus, in this context, include Sikhs, Jains and Buddhists. 2. Freedom to manage religious affairs. According to Article 26, every religious denomination or any of its section shall have the following rights. A. Right to establish and maintain institutions for religious and charitable purposes. B. Right to manage its own affairs in matters of religion. C. Right to own and acquire movable and immovable property and D. Right to administer such property in accordance with law. Article 25 guarantees rights of individuals, while Article 26 guarantees rights of religious denominations or their sections. In other words, Article 26 protects collective freedom of religion. Like the rights under Article 25, the rights under Article 26 are also subject to public order, morality and health but not subject to other provisions relating to the fundamental rights. The Supreme Court held that a religious denomination must satisfy three conditions. A. It should be a collection of individuals who have a system of beliefs, doctrines, which they regard as conducive to their spiritual well-being. B. It should have a common organization and C. It should be designated by a distinctive name. Under the above criteria, the Supreme Court held that the Ramakrishna Mission and Anand Marg are religious denominations within the Hindu religion. It also held that Aurobindo Society is not a religious denomination. 3. Freedom from taxation for promotion of a religion. Article 27 lays down that no person shall be compelled to pay any taxes for the promotion or maintenance of any particular religion or religious denomination. In other words, The state should not spend the public money collected by way of tax for the promotion or maintenance of any particular religion. This provision prohibits the state from favoring, patronizing and supporting one religion over the other. This means that the taxes can be used for the promotion or maintenance of all religions. This provision prohibits only levy of a tax and not a fee. This is because the purpose of a fee is to control secular administration of religious institutions and not to promote or maintain religion. Thus, a fee can be levied on pilgrims to provide them some special service or safety measures. Similarly, a fee can be levied on religious endowments for meeting the regulation expenditure. 4. Freedom from attending religious instruction. Under Article 28, no religious instruction shall be provided in any educational institution wholly maintained out of state funds. However, this provision shall not apply to an educational institution administered by the state but established under any endowment or trust, requiring imparting of religious instruction in such institution. Further, no person attending any educational institution recognized by the state or receiving aid out of state funds shall be required to attend any religious instruction or worship in that institution without his consent. In case of a minor, the consent of his guardian is needed. Thus, Article 28 distinguishes between 4 types of educational institutions. A. Institutions wholly maintained by the state. B. Institutions administered by the state but established under any endowment or trust. C. Institutions recognized by the state. D. Institutions receiving aid from the state. In A, religious instruction is completely prohibited while in B, religious instruction is permitted. In C and D, religious instruction is permitted on a voluntary basis. Thank you so much for watching this video. If you want to buy this book, then link in the description, you can buy it from there. If this video helped you in any way, so please do like and share this video and hit the subscribe button.